Court officer. Court officer. Court officer.
ಸರ್ ಹೇಳಿ.
ಇದು ಸೆಷನ್ ಇನ್ನು ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ವಾ ಮೇಡಮ್?
ಸೆಷನ್ ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ, ಆಗುತ್ತೆ ಸರ್.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ.
ಆದ ತಕ್ಷಣ ನಾವೆಲ್ಲ ಆನ್ ಮಾಡ್ತೀವಿ.
ಓಕೆ ಓಕೆ, ಸಾರಿ ಮೇಡಮ್.
ಮಾಡಿಲ್ಲ ಅಂತ ಸಬ್ಮಿಟ್, ನೀವು ಪ್ರೆಸೆಂಟ್ ಇರ್ಬೇಕು, ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು. ಫೈಲ್ ಮಾಡಿದ್ರೆ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ, ಇಲ್ಲ ಫೈಲ್ ಮಾಡಕ್ ಟೈಮ್ ಬೇಕಂದ್ರೆ ಯು ಸಿಕ್ ಟೈಮ್. ಹೇಳಿ ಸರ್. 22 ಇದೆ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ಎಲ್ಲ ಹಾಕಿ ಅದರ ಸೈಡ್ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದ್ದಾರಲ್ಲ. ಕರೆಕ್ಟ್ ಸರ್. ವಾಟ್ ಈಸ್ ಯುವರ್ ಅರ್ಜೆನ್ಸಿ ಫಾರ್ ಮೂವಿಂಗ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಓಲ್ಡ್ ಮಾಡಿ ಬರೀ ಅಡ್ಮಿಟ್ ಆಗಕ್ಕೆ ಅರ್ಜೆನ್ಸಿನಾ ಅಥವಾ ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾರೆ ಮೇಡಮ್. ಲಿಸ್ಟ್ ಒನ್ ಅವರು ಏನೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರಂತೆ, ಅವ್ರಿಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಲಿಸ್ಟು. ಅದನ್ನೇ ತಗೊಂಡ್ಬಿಡಿ ಅಂತ ನಾನು ತಗೋತೀನಿ. ಹೆಂಗ್ ಹೇಳೋದು, 10:30 ಮೇಡಮ್ ಬರೋವರೆಗೂ ಐ ಕಾಂಟ್ ಟೆಲ್ ದಿ ಪ್ರಾಬಬಿಲಿಟೀಸ್. ಆಮೇಲೆ ನೀವು ಲಿಸ್ಟು ಆಮೇಲೆ ಕರೀತಾರೆ ಅಂತ ಹೋಗ್ಬಿಟ್ಟು ಇದು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳಿದ್ರು ಓದ್ವಿ ಅಂತ
one MFA CPC matter, my lord. Here, RA, my lord, a regular appeal was filed, which is dismissed for default. Against that, a miscellaneous application filed, which is also came to be rejected. Against that order, MFA was filed, my lord, which is pending for consideration. Notice is already issued. It is for the admission, my lord. The OS was decreed, my lord. Against that, FTP was going on, my lord, in the trial court, my lord.
Which year is that?
22, my lord. For
Is never listed after 22?
no, my lord. I am moving the memo, my lord, for several times, my lord, but it is not listed, my lord. Now,
Wednesday, next Wednesday.
Next word.
Lord, the MFA matter, I'm the plaintiff in the suit, my lord, 39 injunction refused, pleadings are complete, maybe taken up. The threat is that defendant has taken out a
Which
paper.
year
copy.
is that?
23, my lord.
Just now he said 22 matter is still pending
Please,
for
my lord, I
consideration.
understand.
We'll see. No,
Maybe
at the no, just the fag end of the vacation, no, all these things, I don't think not
I
possible.
understand, even a week later, at least a date may be given so that I can prepare for argument.
Pose this matter on 15th of October.
Lord, 21 matter, maintenance is not paid by the Lord of the husband.
Next week, we'll see. Yes.
2020 matter, my lord. MFA 2020 matter. Vacating the interim order. Last time argument to ಮಾಡಿದ್ರು, but order pass ಆಗಿಲ್ಲ. Bench split ಆಯ್ತು, bench split ಆಯ್ತು.
What is that?
They have argued.
Finally, 2020.
We'll see. No, even if I say that later list it on so and so date, we can't take up all the matters. Today you see the list, how many matters are there? Will your matter reach? Poses matter on October 24th.
My lord, I'm the husband, like, wife is executing the order, my lord. Last week I moved the memo, my lord. Your lordship has given a date on 12th, but it's not been listed on 12th, my lord.
Which year is that?
24th, man.
Yes, list it. Tomorrow. Yes.
Page by
This RPFC
2020
to vacate interim.
Take all the slips, give some dates. If it reaches, otherwise we can't help it. Yes.
page wise adjournment.
With kind permission, Lordship, one matter, when urgency is there, list number 2, first matter, my lords. Yesterday it was office of raised. Today is the case before the trial court, warrant may be issued. Some urgency is there, my lord.
It will reach, wait for it. Yes.
Yes.
Page wise adjournment, list 1, page 1, cell number 1 to 4. List 2.
Still number 2, my lord. Still number 2, for the petition, my lord. Some settlement talks is going on between the parties. my lord.
Who appear for the respondent?
I am appear for respond number 3, my lord. I am appear for respond number 3, my lord.
Maybe
Is it only same?
It is submitted that the settlement talks are going on. Pose this matter on October 21st.
What's interim stay is there? Steadily.
Interim stay,
There is an interim stay, my lord. Since
if
matter.
it is extended till the next date of hearing.
page number 2, cell number 5 to 8. Page 3, cell number 9 to 12.
My lordship, serial number 11 and 11.1, my lordship. And for the petitioner in the WP number of 1175, in the other WP of 2923 is there for the respondent, my lordship. On short date may be given, my lordship.
Have you informed others?
Yes, my lord.
It
I
can
will
go.
inform.
At the request of the counsel for the appellant petitioner in 1175
There is an
Pose
interim
this
order is there, my lordship.
on 28th of October.
Interim order is there, my
Interim
lord.
order earlier granted is extended till then.
Much obliged.
Page number 4, cell number 13 to 19. Page number 5.
Same reason out of station. Your Lordship.
Which case?
MFA
Ashok Patil.
18, serial number 18.
KH
Have you
Timaya.
informed the other side?
I will inform. Your Lordship.
No, I will inform. You have to inform and then mention all its, wait for your turn. Yes.
Your Lordship.
Page number 5,
My
cell
lord,
number 9.
Still number 22, my lord. Exam for the respondent. We've also filed an MFA against the same order. And I've
24.
22, my lord.
22.
Oh,
And I've informed the other side, my lords, we'll be taking time today. If the two may be clubbed,
write that number.
please, my lords, I'll share the MFA.
It is submitted that the one more MFA is, connected MFA is also pending, post along with so and so on
After the
21st of October.
Serial number 26, my lords. We are for the respondent. RFA 65 of 20. Grace time. Option for the assessment liability filed by the petition.
Inform the other side.
Yes, my lord, we have informed.
Yes, at the request of non-counsel, the respondent, for
Yes.
filing objections. 2022 matter, what objections you will file now?
Senior is not there in town, my lords.
That you tell. Objections, what objections you will file for now? 2022 matter. Post this matter on 4th of November. In all these matters, if the interim orders are there, extend.
Serial number 20, my lords. I'm for the appellant in this matter. I have not filed the additional documents, my lords. Translation copies are not available. I'll file it in the next week, my lords. It'll be taken up in the next week. The first matter, there is a.
No, next week, either if you want an adjournment, it will go beyond vacation.
Please, my lord.
Pose these matters at the request of non-counsel for the appellant on 23rd of October.
First matter, there is an interim order, my lords. In serial number 20.
Interim order is there, extend till
Please.
the next date of hearing. Yes.
Page number 6, serial number 27, 28. Page 7, serial number 29 to 31.
My lord,
Page 8.
serial number 31, my lord, matter get infectious, parties have settled the matter.
It is submitted at
I
the,
filed the memo.
the matter is settled between the parties. The memo is filed to file seeking withdrawal of the petition. Accordingly, memo is taken on record and dismissed as withdrawn. Next.
Serial number 15, my lord.
Eight.
Yes,
Serial number 15, my lord.
Wait, ma'am.
WP 21524.
please wait.
Page number
Call
8,
in.
serial number 32 to 36. Page 9.
Serial number 34, my lord.
Hmm.
I filed my objection, responded by me.
Huh?
The application, if I want to file my objection. For petitioner, idರಲ್ಲಿ stay application ಇದೆ, they are filing an execution petition. This petition against the
We'll hear it, please wait.
ex parte, please.
We'll
Serial
hear it,
number
please wait.
Serial
Yes,
number 36, madam.
yes.
In this, I have filed my wakalat and he has not served the copy. For objections, I have to file the objections.
No, if we have to ask him to serve you a copy, you should be there. The matter is called. Yes,
I'll wait
we'll
for
see.
Page number 9, serial number 37 to 40.
My lord, page number, my lord, serial number 39, my lord. ಇದರಲ್ಲಿ ಅಪೋಸಿಟ್ ಪಾರ್ಟಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ, ಇಬ್ರು ಸೆಟ್ಲ್ ಆಗ್ತಾ ಇದೀವಿ. ಕೈಂಡ್ಲಿ ರೆಫರ್ ದ ಮ್ಯಾಟರ್ ಫಾರ್ ಮೀಡಿಯೇಷನ್, my lord.
Where is the
I
other
have-
side?
I have informed him. ಅವ್ರು ಹೇಳಿದ್ರು ಇಲ್ಲಿ ನಮ್ ಲೀಗಲ್ ಕೋರ್ಟ್
When will you appear before the mediation? Which mediation center?
ಬೆಂಗಳೂರು ಮೆಡಿಟೇಷನ್ ಸೆಂಟರ್, my lord. Any date may be given, my lord. We both are agreed, my lord.
Shahin Shahali.
For the.
I am for the
it is
petitioner, my
submitted
lord.
that, both the parties, that submitted by the councils that there is scope for settlement. Parties and the matter may be referred to the mediation. Parties are, both the parties shall appear before the Bangalore Mediation Center on 27th of September. Registrar Judicial is directed at 3 o'clock. Registrar Judicial is directed to communicate the same. Yes.
Page number 10.
Interim order is there, my lord, in that
Interim order.
earlier.
Look at it, wherever interim order is there.
41, my lord.
Please, my lord, please, my lord.
41.
Page number 10, serial number 41 to 43.
41.
41. Praying for time.
No, MFA of 2014, no time will be granted. Yes,
It's been out of station as is.
Still, we can't help it. How many times the matters have to be adjourned?
Uncle has expired. Kindly give a short attention.
41, pose this matter on 26th of, 26, no further adjournments. Yes,
Page, list number 2, page 1 to 3. Serial number 1,
No.
page 1.
Serial number 2 and 3, my lords, in list number 2. I appear for the
list
KVA
number
that-
2 will not be called now.
My lord.
What do you want?
This one,
My lord, I'm seeking for an adjournment in both the matters, my lords. I have not received the IA. I have to file my objections. It may be taken up any other day, my lords.
My lord, I am appearing for appellant in all serial number 25 in the first list and second list 2 and 3. Have it day after tomorrow in case we have served copy because there is an urgency. Have it in case they are seeking these 3 matters to be clubbed.
Council should serve the copy of the appeal memo on the council for the respondent. Pose these matters day after tomorrow.
All 3, serial number 25 in the first list and
Serial number?
25 in the first list
Yes.
and 2 and 3 in the second list.
Yes, yes, next.
Please.
With kind permission,
Page
kind permission. One MFA, my lords, that's my lords have heard it. That is in respect of one layout, my lords. Posted on 30th. May I request any date next week, my lords, on Monday, Tuesday?
What is happening in that?
That is, my lords, that superimposing the layout, my lords,
No,
that.
what is that, like, as if there was a settlement, that's what the matter is.
Yeah, that, my lords, they
Hmm.
did not turn up with any proposal further because we have asked any surrounding or 10 kilometers surrounding, my lord, they did not give any such.
But next Wednesday, give that. Yes.
I'll
Call
do
the next.
25. Next one,
Somebody was mentioning about 15. No, 15, that the girl was saying.
this one, number 15.
15, ma'am, 21524/2024. Kindly please date ma'am for objection, ma'am.
21524. You appear for the respondent.
Respondent 1 and 2, ma'am.
Have you informed the other side?
Mm.
Please wait. When the matter is called, you can ask for it.
Thank
Yes.
This one, for preliminary hearing, serial number 1.
My lords, I appeal for the petitioner in this matter, my lords. My lords, we have initiated settlement talks, my lords. So if my lords may be kind enough to,
Where is the other side? Whenever this matter list is, then the settlement talks will start and they will stop by today evening when the matter is adjourned.
no, my lords, my lords may accommodate after vacation, my lords. Kindly
It is
try.
submitted that the settlement talks are going on. At the request of counsel for the petitioner poses matter on 24th of October. This next.
My lords,
Serial number 2.
with my with your kind permission, my lords, there's one more matter, my lords. Party's name is Harmeet Singh. My lords, have Harmeet Singh is the party's name, my lords. My lords have,
Mentioning now, how can you, when the matter, first matter is called unconnected things, how can you mention? Yes, next matter.
Serial number
Sure,
2 attend, serial number 3. Please, Rajshekar.
Appealing for petition in this matter, Lord.
Yes.
Petitioner, the family court has directed the petitioner to furnish copies of the visa, copy of the passport, as well as to sign at Annexure C and Annexure D of the passport application of the minor child, Lordship.
Hmm.
Lordship,
Please come to the order. Page number
page number 44, Lordship.
40.
4.
Please read it.
Pursuant to IA number 6 and enclosed documents, it is stated that for traveling minor son of both parties, namely Ayan, Ananda and Ayan to UK, the copies of the passport, visa stamp, and copy and signatures of the respondent in Annexure C and D issued by the Passport Authority of India is required. It is stated that both the parties are presently working in UK. Having regard to the facts and circumstances of this case and in the paramount interest of the ward, the respondent is directed to furnish copies of the passport, visa, stamp copy, and cooperate with the petition for signing of Annexure C and D, Lordship. Now, Lordship, the respondent herein is trying to issue
Perused
the,
IA number 5 filed under so and so. In view of no objection submitted with the counsel for respondent, IA 5 is allowed.
Lordship, IA number 5 is for representation, Lordship.
IA 5 is for?
IA 5 is for representation. GP holder of the respondent in the present respondent in the family court, Lordship.
No, both the father and mother are in UK.
Lordship, both the father and mother are in UK, but Lordship, what may be seen?
Where is the boy? Boy is staying where?
Boy is in Mysore
With whom?
with the grandparents, Lordship. Lordship,
Oh.
also it may be seen that both the parents are only there for temporary work, Lordship. They are not permanent. They're working in TCS India, whereas they have been stated to work there for a period of time, Lordship.
So
Now,
what happens if the boy comes to UK? He's not a citizen of UK. You know, he has to come back once after whatever that 6 months time, whatever the visa is given.
Lordship, the respondent is trying to relocate the child, Lordship. That is why we are opposing it. Also, Lordship, the order, specifically the order, if it is to be challenged, Annexure C may be seen at
Where is he
126.
staying? Is he staying with the paternal grandparents or maternal grandparents?
Lordship, he is with maternal grandparents and sometimes the paternal also take care of the child, Lordship.
There must be some order to that.
Lordship,
Any order by the court?
page 126 may be seen, Lordship.
126.
Lordship, to challenge the order wherein the family court has specifically directed me to sign the documents, Annexure C and D.
Oh, that I understand.
Lordship, I need not sign. We are challenging that order. As to the custody, Lordship, as to the custody, no custody rights have been given to any of the either of the parents, Lordship.
No, but presently, in whose custody is the question?
He is with
He is
the
with-
better.
No, he is, if it is maternal grandparents, the boy is.
Yes,
That
yes.
is, he is in the mother's custody
Mother's custody.
as of now.
Lordship.
Now, for moving the boy out of the country, then both parents have to sign or the whatever the documents are there, is a minor.
It is not required, Lordship. It is not required. When I don't give consent, I cannot be forced to give my consent, Lordship. And that is why Annexure.
That is the order.
Lordship, I have been told to put signatures, but I am not
No,
required.
that is what is the order.
That is what
It
the
is
order.
not forcing you. Court is directing you to do it
Lordship, but
in the
this-
interest of the minor.
But in this present case, Lordship, the respondent has never approached the passport authority, Lordship. She has just come before the court and asked for a direction, whereas there is proper rules and regulation that is established under the passport rules.
Let us
Lordship.
see your objections. Let us see your objections before the
Lordship.
trial court.
Objection is at page number 124.
Hmm.
Lordship, here we
Let's
state.
see first, let's see what is your objection.
Lordship,
What did you say there?
Lordship.
What the court has not considered. Read it.
We say at para 2, Lordship, we say that the applicant is trying to drag the above case by filing previous application without adhering to the due process of law, Lordship.
Yes.
Respondent has to approach.
3
the
and
passport-
4 has nothing to do.
Lordship, 3 and 4.
Hmm.
It's false. Respondent has no objection. They have stated in the application, which is against false. That's what we have stated. Has not intimated the owner about the relocation, Lordship. Then again, at para 7, we say, para 7 at page number 125, Lordship.
Hmm.
It says that there is a specific mechanism at para 7, I will read the whole para,
Hmm.
that the application filed by the applicant or petitioner has no bearing in the above case. And such directions are sought by the petitioner or applicant is not maintainable at this junction. That there is a specific mechanism prescribed under law that is provided.
Why are you making it so complicated, your affidavit? What is that? You can tell the court.
Lordship, they had raised these objections. The mechanism is there, Lordship. At the
No,
very-
what is the mechanism? You can tell.
At very page, Lordship, 126, it may be seen.
Yes.
This is the annexure C, Lordship.
Hmm.
That says specimen declaration by the applicant's parent or guardian for the issue of passport to minor when one parent has not given consent, Lordship. There is specific direction, like there is a specific process where the respondent must approach the appropriate authority. That is a passport authority under annexure C for issuance of the
When
passport.
this is the case, now, when the matter is before the court is considering about the custody of the child. If the court gives a direction, so why not? Why should we look at this when one parent has not given consent?
Yeah, I'll produce a judgment to that effect.
Hmm.
Already this honorable court as well as the Andhra and Kerala High Court already considered this issue brief.
Oh, what I'm not able to understand is, if you sign the form, what will happen?
Lordship, our contention is that their affidavit may be seen, Lordship. At page 123,
Tell the court, what is it?
Lordship, it says, I further swear on oath, if the respondent is not provide the above said documents, it's impossible for me to took my son along with me to UK and provide motherly love and affection and education to my son, Lordship. One is that they are not.
It is a classic case where both of you are trying to, just trying to litigate the matter, nothing else. No, if I can understand, if it's your grievance that the boy shouldn't leave India, that is one aspect the court can understand. You can file an appeal. You can come before this court. Now, what you say is, without me signing it also, she can take the boy to UK. So why should I sign? Does it make any?
Lordship, but the reason here is that since we are objecting to it.
If you're no, but you say that without your signature also, she can go abroad. She can take the child abroad.
Lordship, our contention here is that the family court has not looked into the issue, Lordship. This judgment may be seen. Lordship.
It's not about some legal point. How are you going to be benefited by this point? That you please tell the court.
We do not, see, Lordship, in this case, if we sign the annexure D document, in which both the parents have to sign, it will be declared that we are allowing the child to go out of India and it will be on our responsibility, Lordship.
What responsibility?
Lordship, we have to take care. In here at annexure C, the respondent also has to file a declaration that she is residing at what residence. All those documents we don't have. We don't know where the respondent is residing, Lordship. We don't know about the minor child. We have not contacted for a very long time. They are not allowing us to contact the child, Lordship. Earlier, they were allowing, now they are not allowing me to contact as well.
That is a different cause of action.
Lordship, since we are challenging the whole order, Lordship, since the family court has not considered our contentions, we are challenging it before this.
So now if I say basing on this judgment, basing on this order, let her apply and let there be a direction to them to grant whatever the process to be completed, then you are happy with it.
Lordship, she may apply to the passport authority under appropriate provisions, not that I have to sign the documents, Lordship, because
Who filed the JNWC?
GNWC I have filed, Lordship.
Oh.
And they have not appeared there. They have ex parte, Lordship, there.
Hmm.
And there is restitution and there is
Let's see
also
what this judgment says.
Lordship.
Hmm.
This matter is to issue this was in reference to issuance of passport to the minor child by considering the application when the passport authority was directed, Lordship. In this case, at para 17,
Hmm.
it is relevant to note that in Schedule 3 of Passport Rules 1980, it is stipulated under the where the applicant parent is not in position to get consent of the other parent for whatever reason, the parent applying the passport of the minor child may sign the form and
When both
submit.
of you are before the court, why should the court go to this particular provision and why should the court look at it?
Lordship, because I am not giving consent. I do not want the child to go outside India, Lordship.
Court, that's order of the court. Why it is, how is it wrong?
Lordship, since we are only there for temporary basis, both the parents are
That is what you have to argue. This is, if you're not interested, fine. Because there is some provision is there under the Passport Act that she should go. The court has passed an order that because both the parents are there, you are seeking custody, you have submitted yourself to the jurisdiction of the court. So court exercising the parent patria jurisdiction, whatever is in the interest of the child has done it. There might be provisions that would arise when you both of you are not before the court. You are before the court.
We are before the court.
Yes.
Lordship. Lordship, one more. This may be completely read, Lordship. At 18,
Yes.
it says, in the rules and also in the aforesaid annexures, there is no mention that the petitioner has to obtain permission from the court on the ground.
This arises altogether in a different scenario.
Lordship, in this case, it may be seen that both the parents are staying in a
Yes.
co-shared house.
Yes.
Lordship, both the parents are also there only on the temporary basis, Lordship. They'll be called back
No,
again.
the boy is there in how many days they will for the visa will be given according to you? He will be given a permanent residence of the
Lordship,
UK.
he might not be given a permanent resident, but the respondent is intending to relocate the child, Lordship. It may be seen at affidavit, it is very clear. They are stating, I want to give motherly love, I want to educate the child and I want to bring them here, Lordship.
Both of you will work in UK.
They
Both of you will work in UK and the boy will forever stay in
Lordship,
the
we are
parents'
there only for temporary basis.
How
Lordship.
many, what is the temporary?
Lordship, there is one project that is going on for my company. Once it is over, I'll be back.
When
to
will it
India.
will go over?
Lordship, it is usually for 1 or 2 years.
It's
That is
not
what-
usually, you have to
Lordship,
say
it has been
specifically.
directed by I have instruction that it's 1 or 2 years, Lordship, maximum.
And then 2 years the boy will be here.
I am not aware exactly. Now it's been over 1 year. It's over 1 year that the petitions approach. Lordship,
Yes.
may be seen also this honorable court
Yes,
in this one more judgment
yes. Pass
As
on
per-
all the judgments at once.
has also consider this aspect, Lordship.
Yes.
There's a clear provision. The respondent is trying to overlap it and get an order from the
Yes.
court, Lordship.
Yes, yes. Which para?
In this case, it was a case wherein wherein the parent was required to,
The petition is before this court seeking issuance of a writ of mandamus,
Lordship,
directing the
towards
second
the
respondent.
passport authority to consider the application, Lordship.
This
if-
is, no, you can't, you cannot say this judgments will apply to you.
Lordship, but if the rules are already prescribed, and the respondent has never approached the passport authority, it has overlapped it and come before the court to get a direction. Lordship, when a rule has been prescribed, the respondent might approach that way. Why they are overlapping and coming and getting an order, Lordship?
I understood.
these-
Submission. Yes.
These orders, these rules or prescriptions have not been considered by the family court, Lordship.
Please come. agreed by the orders passed in. I number 6. In MC number 238 of 2022. The presented petition is filed. Who had filed MC?
Lordship, MC 238 was filed by the respondent, Lordship.
MC 238 of 2022 is filed with the respondent hearing. In that, she has filed an IA seeking permission of the court. She has filed an IA. Where is the affidavit in the IA?
Affidavit at the IA, Lordship, is at page number 120 to 123.
120?
2 and 123. Affidavit at the IA.
Taking a direction to the respondent to produce his copy of passport, visa stamp copy, and also signature upon the annexed DNC in the interest of annexed DNC within brackets specimen declaration by applicant's parents or guardian for issue of passport to minor in the best interest of justice and equity. It is stated that she's working in Tata Consultancy Service on company reputation. She's working in UK, but her minor son is staying in Mysore along with her mother due to visa and passport problem. And she could not take him to UK. And for that, the no objection of the respondent. The objection of the husband is father is required. The husband is not providing the said document. It is impossible for her to take her son along with her to UK and provide motherly love and affection and education to him. If this application is not allowed, she'll be put to irreparable loss and hardship. For that, objections are filed by the husband stating that the wife is trying to drag the case by filing frivolous applications without adhering to the due process of law. It is not for divorce, it is for restitution of.
This one is restitution, Lordship. I have filed for divorce, which is at 63 of 2023.
Respondent has filed MC for restitution of conjugal rights, and the petitioner herein had filed an MC seeking divorce. It is also stated that the wife had not intimated before the court regarding her transfer relocation to United Kingdom, nor has she intimated the respondent as to the whereabouts and custody of the minor child. The petitioner had left the country hastily in the year 2023 without making any arrangement for her minor child or intimating about the arrangement of the minor child to the court. It is also stated that the wife is keeping the rights of the husband in dark by not allowing the husband to talk to his minor son. And she cannot file this application before the court. The custody of the minor child in Mysore without the consent of the husband by itself is high-handed and unlawful. The application filed by the wife has no bearing in the case, and such directions as sought by the applicant is not maintainable at this juncture. There is a specific mechanism prescribed under law that is provided to adjudicate in this regard, and the application filed by the applicant petitioner is liable to be dismissed in a threshold. The trial court, considering the objections filed by the husband, had allowed the application. While allowing the application, the court has observed that both the parties are presently working at United Kingdom and having regard to the facts and circumstances of the case, and in the paramount interest of the ward, the husband is directed to furnish copies of the passport, visa, stamp copy, and cooperate with the petitioner for signing the annexures C and D documents immediately. The wife is directed to visit the husband with prior intimation at UK. Agreed by the said order. The husband is before this court. Then counsel appearing for the husband submits that he cannot be compelled to sign it. And according to him, he is deprived from visiting his son. And the boy is staying at Mysore along with the maternal grandparents. It is this case that the wife is going to relocate the child. Further, it is submitted that for when he cannot be made to sign those forms or give consent when there is a procedure available under the Passport Act for a single parent to when one parent has not given consent, there is a procedure prescribed, and she has to file an application under the same, and she cannot seek a direction from the court asking the father to give a consent for the same. We had relied on the judgment of this court in case of Nancy Nithya versus Government of India and another, reported in 2022 SCC Online, Karnataka 1614, and another judgment of the High Court of Telangana in case of L. Deepika versus Union of India and others, reported in 2022 SCC Online TS 2481. It is submitted that in case of Nancy Nithya, a mother has filed a writ of mandamus directing the Regional Passport Officer Bangalore to renew or reissue the passport in terms of her application dated 2/7/2022.
There are 10 days.
The mother, who is having the custody of the son as on the date, seeks to visit Australia to celebrate Christmas along with her son, and accordingly applied for renewal reissuance of minor's passport on the website of respondent number 2. She has not submitted the specimen signature of her husband for reissuance of the passport in favor of her son. Despite passage of 2 months, there was no communication from the hands of the second respondent, but was informed that the minor son's passport would not be reissued as a minor son's father. Consent was mandatory for renewal reissuance of the passport. Then the court had considered Section 24 of the Passports Act, which empowers the central government to make rules for carrying out the purpose of the Act. Then Clause 3 of Section 4A of the rules, which deals with the application for a minor's passport. Then the court has further considered how the procedure is in respect of a single parent where the other parent is not giving consent. Considering all this, and held that as per Schedule 3 of the Passport Rules 1980, where the applicant parent is not in a position to get consent of the other parent for the whatsoever reason, the parent applying for passport of the minor may sign the form and submit a sworn affidavit as per exigency, and accordingly, the court has directed the second respondent to consider the application of the petitioner for issuance, reissuance, renewal of the passport to the minor son, bearing in mind the observations made by the court within 7 days from the date of receipt of the copy of the order. In case of L. Deepika, also, Schedule 3 of the Passport Rules 1980 is considered. In this case also, a mandamus is sought to issue passport to the minor. In those circumstances, the court had directed the passport authorities to consider the application submitted by the petitioner and issue passport to the minor son of the petitioner. Basing on these judgments, learned counsel for the petitioner submits that when there is a procedure available and bypassing the same, they cannot file an application before the court, and the court cannot direct the party to direct the father to sign the said form. It is submitted that the court, without considering any of the objections that are raised by the father, had passed an order, and the same is liable to be set aside. Next para. Having heard the learned counsel for the petitioner, peruse the entire material on record in the judgments that are relied on by the learned counsel. First and foremost, the judgments that are relied on by the counsel for the petitioner do not apply to the facts and circumstances of the case. In those two judgments, the mother who has applied for the passport, when it was not granted by the passport authority, had filed a writ of mandamus and sought a direction to the passport authority. In those circumstances, the court, when the passport authority was not issuing the passport, as the father's consent was not there, then the court had directed the passport authority to consider the case of the minor boy as per Schedule 3, wherein without the consent of the other parent, however, the single parent can file an application. Coming to the facts of this case, both the parties are before the court. Admittedly, both of them are working in UK. And what is the age of the boy?
6 years.
A boy aged 6 years is residing with the maternal grandmother. It shows that the custody of the boy as of now is with the mother. And it is not the case that if the mother is completely going to relocate the boy to UK, or there is any intention on her part, it is always open for the husband to file an appropriate application before the court. When it comes to the other contention that the father is not able to exercise a visitation, even on that count also, he should have come up with an appropriate application before the court. And as far as this application is concerned, it has to be dealt with independently. Even for a brief period, if their projects are at UK, even if it is for 1 year, this court do not see any reason why the boy should not be with the mother. And even when when both of them are there, if the father wants to have the visitation of the boy, the father can, it is always open for the father to seek a direction to the respondent, to seek a direction from the court with regard to his visitation rights. Station rights. Now, in those circumstances, the mother has every right to take the boy to the UK where she is residing. When coming to the provisions of the Passport Act, that those arise in a case where the mother had come before the court questioning the action of the passport authority. When both the parties are before the court, and in the interest of the minor, when a particular direction is required, the court exercising the parent patria jurisdiction is empowered to pass such orders which are in the interest of the minor. And while exercising such a jurisdiction, the court had passed an order directing the father to sign the document for the purpose of obtaining visa/passport to the boy. In the considered opinion of this court, there is nothing wrong
Make
in
one
the order
submission.
that is passed by the court.
Page 126, it may be seen. Annexure C may be seen, Lordship. Just one, page 126. I cannot put my signature there, Lordship. It is only for one parent to put signature. The court is directing me to put signature there. There is no.
That's what will
provision.
fall with the now wherever for obtaining in his contentions to record, he submits that even for obtaining a passport, the completing the formalities, his signature is not required as if a single parent wants to take the child. Next, the contention that that he need not sign if it is a consent of a single parent. Now here, the court is not considering here it is not the mother who has to independently apply, but the court is considering the interest of the boy and the father who is before the court. So in that case, court is passing an order. So the father cannot take the shelter under the said Schedule 3 of the rules, and accordingly, the petition is dismissed. Next.
4. Ashwatha Party for petitioner.
Yes.
With permission of the court. But this is for an
What happened to the notice?
notice is served on the counsel who was
Counsel
representing.
appearing the petition is permitted to take out hand summons, appearing for the respondent in MFA, filed with the respondent herein, and file a memo to that effect by 12/9/2024.
We filed a memo,
Where is
served a
that?
copies on,
You appear?
he is appearing.
Yesterday, Lords, I need short accommodation, my Lords.
What
Yes,
is the-
Rajshekar.
This rest, it is submitted that.
It is served 1 week back. I think they could have
Says
taken
Rajshekar
instructions.
has instructions to appear for the respondent.
I have entered appearance yesterday, so I filed
He
Wakala.
has entered appearance yesterday. His name is not reflecting in the false list. Poses matter on 24th,
Could it be on 27th, 26th or 27th?
26th,
I have-
also on 26th. Print the name of so and so.
26th of this month,
Yes.
please.
Grateful.
Till number 5. Anusha, yes, for petitioner.
For the petitioner, my lords. This writ petition is filed challenging the dismissal order for the application filed under section 311 of CRPC for cross-examination of the respondent, my lords. The reason is, my lords, on On 19/3/2024, the respondent files her assets and liabilities. In that assets and liabilities, she only
They appear for the husband or the wife?
husband, my lords.
Who filed this, wife had filed?
Wife.
Miscellaneous number 311 of 2013.
Yes, my lords.
Which year is this? 2013.
13. But it was actually dismissed in the year 2017, my lords. Later, it was remanded by the order of the Honorable High Court in the RPC 170/2007.
Where is the impugned order?
Impugned order. Annexure. The impugned order of 311.
Number.
Annexure C.
Page number.
This is the RPC order, my lords.
Page number is 23. That is earlier order.
Yes.
Annexure C is earlier order.
It was actually dismissed in the year 2017.
Where is the impugned order?
Annexure, Annexure M, my lords, page 229.
Please come to that. Please read that order.
Kindly turn page to 237, my lords.
We'll read from the beginning.
Okay.
What is the order dated 19/12/2022?
Yes, my lords. 19/7/2020.
19/12/2022, what is the order passed? You wanted an application, you filed an application under section 311 of so-and-so to recall order dated 19/12/2022.
Yes, my
Where
lords.
is that order of 19/12/2022? Pass over, please,
My lords,
go through and come back. Yes, next matter.
Number 6. Nandita Haldipur, for petitioner.
I appear for the petitioner in the matter. In this matter, we have challenged the interim order passed for maintenance, directing payment of 30,000 where I have claimed 42,000. And now the
enhancement of maintenance.
respondent has also challenged that order.
Which is that writ petition?
That is 16756 of 2023. So this may
Post
also,
along with so-and-so give.
and I may be permitted to serve the notice on the council. appeal.
Post along with so-and-so, and the petition is permitted to serve notice on the council appearing for the petitioner in the other writ petition. Post this matters on 15th of October.
Cell number, parted matter, cell number 7, Lakshmikant K. For petitioner, S.V. Prakash.
I have sent the joint memo to the learned counsel, my lord. He has to go through the joint memo and
For how many days it will go on?
Kindly have it on Saturday, madam.
Huh?
Saturday.
my lord. This is
Post
the
this matter on Saturday. Yes, next. At the request of learned counsel for the respondent or you are for the petitioner.
Please.
Yes, petitioner. Next matter.
Cell number 8,
I appear for.
PK.
I appear for. This is the matter, my lords, and last occasion, my lords. This matter, my lord, where chamber conciliation was also taken place of a Mangalore matter, my lords, where. My lords, the last date, my lords, are pleased to pass an order. There are, my lords, to appear before, doctor, my lords.
What has happened?
But they did not appear,
my lord.
My lord, 79/24, yesterday it's supposed to be appeared.
Yes,
my
yes.
lords, and the doctor is saying that unless I don't get any direction from the court, I cannot, right, let there be some.
My lord, my client appeared there and the doctor has given this thing that it is mentioned that they did not came with the child, one wife and child, and the father reports of the today's date as the date of the consultation as advanced by the court, and further reports of the previous attempts to meet the counselor, but the same not has been completed. Consequently, the father advise the counsel legally is further options.
Pass on that.
They did not came up with the child, my lord. The father was present and fees they have paid.
Yes. According, what are your instructions?
My lords, we sought on 16th, we gone to the hospital. And my lord sought for appointment for 17 as per the directions of this honorable court. My lord, there is an acknowledgement from the hospital that we have visited on 16th, my lords. And there is my instructions to say that, my lord, doctor has said that You cannot get an order, my lord, so you let there be a notice to me for the direction from the court to the hospital so that I can examine, because that doctor works in KMC hospital. This is my instruction, my lord. They have visited, there is an acknowledgement, my lord.
KMC hospital.
KMC hospital.
What is the doctor's name?
Doctor's name is
Kamath.
Dr.
And
Avinash.
Anivas G. Kamath.
In the last
Dr.
order, it is
Avinash G.
like
Kamath,
Dr.
my lord.
Avinash G. Kamath.
Yes, my lord.
Hmm.
We have an acknowledgement of requesting
Please
for
come.
appointment
On
on
13/8/2024, this court passed an order where both the parties were directed to be present before Dr. Avinash G. Kamath on 17/9/2024 at 11 a.m. Then counsel for the father submits that the mother has not turned up along with the child and he went to the hospital. It is on instructions and counsel for the respondent submits that in fact they went to the hospital on that day.
69, my
On
lord. We went
16
on
they went.
69 seeking appointment for 17.
Seeking appointment for 17th, and they're informed that by the doctor that unless and until there is an order by the court, which is communicated to the hospital, he cannot examine. So what will be the next date? There will be an order, registrar judicial will communicate.
Please, my lord. Then
And he said-
any date, my lord.
Any
fix
date,
it
any
then.
date.
Considering all this.
My lord, I have filed my NOC of color in the court.
Considering all this on.
It is not reflecting.
My lord, sir, till 1/10/24, there are exams. From 19/9/24 to 1/10/24, child has got exams. Any date after 1/10/24.
No, I think that the holidays it is better.
After
holidays. No, in holidays it's better. They stay in Mangalore only.
Now they going. Please, my lord.
That's better for the child also. On
Immediate on second, my lords.
second?
Yeah, second.
I think that's better. On second.
Because if they immediate after exam.
If the parents along with the child shall appear before the doctor Avinash G. Kamath at 11 a.m. The doctor shall interact with three of them independently and then basing on the requirement shall give counseling and a report shall be placed before this court by the next date of hearing. The registrar judicial is directed to communicate the same to, what is that hospital's name?
KMC
KMC hospital.
That Dr. Avinash G. Kamath, KMC Hospitals, Mangalore. The registrar judicial is directed to communicate the same to the hospital.
And my
Post-
lords, there's another, my lord. There was, my lords, a direction for a father to consent for renewal of passport of the child.
That was not done.
Not done.
No, my lord.
Then, my
thing
lord,
is-
today they are trying to interpret, my lords, in such a way that, my lord, they don't want to comply this.
No,
because
actually
there
the
was
father
no
is
submission.
ready to give the consent, but he has to go to the Chennai embassy.
No,
But
there
they
is
are not
an-
allowing it. They are saying they have filed one memo. And in this memo, the father should consent because your order has directed for the permission of the visiting rights. They are not allowing to see the father.
Let
my
them
lord.
not, my lord.
That is my
17/8
question.
17/8, my lords, we were present.
No.
They did not come, my lord.
No, there are 1, 2, 3 directions. 1 is to you, 2 to him, 3 to you. If 2 is not complied with, they will answer to that. If direction to you is not complied.
No,
with,
my lord, I am ready
that
to
is-
comply
that
with,
is-
I am ready to comply with, but what I am saying that I have to be present with the child.
Let us see that. It is submitted that the passport of the daughter, who is a US citizen, has already expired.
Yes.
And it has to be renewed.
Yes.
Then counsel for the father submits that if the passport is renewed, it's very likely that as the girl is a US citizen, she'll be taken out of the country. Then counsel for the mother submits that she'll deposit her passport before the trial court. Considering the same, it is directed that the mother shall deposit the passport to the trial court and father shall give his consent for renewal of the passport. You will sign on the application. Why you are present
it, my lord.
required
That
before
is
the
all.
consulate?
Because my lord, it means not allowed to give the visiting rights. He want to see the child.
Again, you're mixing up two issues. It's an independent issue.
yes.
If it is not being done, that the different course of action court will take.
Yes.
On the last occasion,
I will.
regard to the father's consent, an order is passed. It is submitted that the respondent, the father has not complied with. Then counsel for the petitioner submits that, for the father submits that by the next date of hearing, the consent will be given by the father. If the order of this court is not complied with, appropriate action will be initiated.
My lords, may I request
Registrar
passport and the
judicial is
visa, my
directed
lords.
to communicate this matter. Delete from the caption part.
I request passport and visa, my lords.
Passport / visa. Yes, next.
Highly placed.
Cell number 9. Vanu Prakash VG for petitioner.
I appear for the petition in this case. My lord, the Honorable Apex Court has directed the parties to be present before the Bangalore Mediation Center on 39 virtually for a mediation. So my lord may currently consider that.
Appear before the mediation center. When is the date? given by-
39,
20?
September 30th.
September
30th.
30th. Where is the, you have the order?
My lord,
Copy of
yesterday the matter was taken up yesterday only. So.
It is submitted that the Honorable Apex Court has directed the parties to appear before the Bangalore Mediation Center on September 30th. At what time? Time is not mentioned. On
11.
September 30th. In that view of the matter, pose this matter on 15th of October.
Yes, my lord.
Yes.
Yes.
Yes, next.
Cell number 10. Suya Gerale.
Here for the petitioner in the connected matter. This is the matter where lordships passed the conditional order yesterday. That full deposit amount. had to
Kindly
be-
pass over, my lord.
Awesome. Yes, next.
Great.
Thank you.
Cell number 11. Cell number 11. 11 urgent, 12. Nanjappa.
Lordships for the petitioner, my lord. This matter, I filed the applications yesterday.
Yeah, they have filed
served
three
it all.
applications seeking the bank statement of the respondent for the year 2015 to 24, whereas the application was filed on 3/3/21, my lord. So as per the Apex Court guidelines, as per the Rajneesh versus Neha.
No, please wait.
So
These are
it's-
two, please, 1 minute. There are two writ petitions.
Yes, ma'am.
What are these? Questioning the maintenance.
Yes, ma'am.
How much is granted?
30,000, ma'am.
30,000.
You need enhancement.
Yes, ma'am.
30, huh?
The wife is asking for enhancement. and-
So how much maintenance is sought for?
Lordships, I asked 5 lakhs, my lord.
What is the income of the husband?
He's got 4 companies in Canada. And yeah, all those companies, may please have page number 124, my lord.
No, we'll go into that.
I'll just,
So according to you, what is his income?
his total income, his net worth is more than $50 million. And that's under public domain, my lord.
No,
My
when
lord,
has he filed a statement of assets and liabilities?
I have filed my financial details and disclosure affidavit, my lord. The wife has not filed any bank
What is
statement.
wife doing?
Wife, she came back here because of some dowry harassment, my lord. And since then, she was unemployed. And her mother was suffering from dementia. So she was taking care of the mother. Mother was also taking care of her from her accounts. And last year she demised. So now she's taken up some employment.
The facts is, my lord, first she files one maintenance application before the family court. She withdraws that. Again, she goes to Canada. Then
No,
she
that-
can't.
all those-
One
all-
minute,
all
sir.
those-
Let me make a
I
submission,
just-
sir.
I-
So he is breaking my thoughts, my lord.
Let's take it. Just okay.
After filing the maintenance there in Canada, it got dismissed. Again, she comes with a fresh application, again, my lord. I've already spent around 40 lakhs in contesting that application there, and it got dismissed with the cast. Now, my lord, now they are coming with the multiple application that I have to produce all my bank statement, tax returns, but she is not.
Lordships,
Which
may please see
application
the,
is this?
may please
Maintenance
see
application. my
the
lord.
previous orders of the lordships. I filed those applications, she has to file the objections. After that, we'll make the submissions, my lord.
Find the respective bank statements
Yes.
pertaining to their individual and joint account, if any, from 2020 till date. Petitioner will come up with the court and fund necessary application with regard to details of the husband. So, have you filed?
I'll file my objection. It
Yes,
was
that's
served
it.
on me
Let her
yesterday,
file.
my lord, but the
Then we'll
question
take it
here
from back.
is.
No question. When there is an order passed on 22/8/2024.
Yes, my lord. My lord.
You should
If
come
my
with the
only,
order.
only my statement is, yesterday he gave the application to me, it was served, I'll file my objection. Now the question,
His objection is different issue. What about this, your bank statement?
back statement, at last date of hearing itself, I produced a couple of my tax
Listen,
returns.
It's not
My lord,
couple. I said pertaining to their individual and joint
Yes,
account, if any.
It
from
is
20
only
to
now in the application is seeking about the company's details and the bank statement, my lord. It was only yesterday.
Please understand, it is not what he is seeking. It is about what is the order of the court.
My lord, I told I am ready to file my bank statement. Then he told he'll file a necessary application to that effect with regarding to multiple companies, my lord. It is only yesterday I was served with the copy.
Submitted that. The counsel for the
I pray for some time.
wife had served I've served what is that? What is?
I served 3 applications, my lord.
3 applications on the counsel for the.
They also filed my
respondent.
bank statement.
And the counsel for the respondent husband seeks time to file objections. And also as per the directions of this court, the details of the joint and independent bank accounts. Pose this matter on 31st of October.
The other side
Wait
may
for-
be also be directed with the financial details, my lord. She has not filed financial details in the lower court, nor IT returns.
With the bank statement she has filed.
Only today, yesterday she has filed, she has not
No,
filed.
no, yes, you come up with that. Next. So Mr. Nanjappa MG is directed to take notice in WP number 20749 of 2023. He is directed to print his name.
Cell number 13. Ramesh KR for
I'm grateful,
petitioner.
my lord.
Motion
Sir.
Yes.
But the impugned order is at annexure E. But fact matter of this case is this, my lord, the marriage between the petitioner and the respondent was solemnized on 29/6/1978. Lord, a male child was born to them in the year 1981,
You appear for the husband or the wife?
husband, my lord. But thereafter, my lord, in the year 1987, that is on 17/3/1987 itself, they have separated from each other by entering into an agreement among themselves. Wherein, my lord, they have explained as to why they're separating each other, my lord. I have extracted it, my lord. It is in
What is
Kannada.
the present application, present impugned order?
Now, my lord, after lapse of more than 35 years, my lord, the respondent herein is living with the son who is aged about 40 years now, my lord. Now, she has met,
Age of the petitioner.
petitioner is 65 years, my lord. 65 years. Now, my lord, she has filed a petition under section 125 CRPC seeking maintenance after lapse of 35 years. My lord, there is a bar under section 125 class 4. But she cannot file this petition, my lord.
What is the bar?
Lord, so 125 CRPC reads, my lord, no wife shall be entitled to receive allowance for the maintenance or interim maintenance and expenses of proceedings as the case may be from the husband. Under this section, if without any sufficient reason, she refuses to live with her husband if they are living separately by mutual consent. Now, my lord, they have entered into a written agreement. I have enclosed a copy of that, my lord.
Page number? Page number.
Lord, it is in Kannada. I have translated it and called out, my lord, at page 6 of my petition, my lord.
Yes.
Wherein both the petitioner and the respondents have categorically stated that, 7th line, it commences, my lord. They lived together only for about 4 months. There was no proper understanding between them. They cannot live together. As such, both of them have voluntarily agreed to live away from each other. They do not have any other marital relationship. They are not approaching any court of law about their marriage, and they have agreed to lead their life according to their wishes. This is the agreement entered into between them, my lord, on 17/3/1987. Since then, my lord, she is living away from the petitioner. Petitioner is away from the petitioner along with the son. Now, my lord, after lapse of 35 years, my lord, the lordship may now peruse the petition filed by them, my lord, at annexure B.
Yes.
Lordship may kindly peruse para 3, my lord, at page 18.
The petitioner submit that the parents of the petitioner have spent all the marriage expenses and they have also given one gold neck chain, one gold ring and dress materials to the respondent and spent more than rupees 1 lakh for the said marriage of the petitioner with the respondent. On the same day, the parents of the petitioner have also given one set of gold so and so, so and so. Then, my lord, petitioner and the respondent are living for a period of 3 years in the house of the respondent. Submits that.
Come to the impugned order.
Please.
Page number.
Page number, annexure, my lord, page number E, the reasoning, my lord. Page 32. But insofar as my statement of objections is concerned, my lord, I have stated the same thing what I have submitted.
The reasons.
Please, my lord, para 10, my lord, at page 30, in page 32.
Yes.
The petitioner claiming to be the wife of the respondent has filed this petition under section 125 CRPC, seeking monthly maintenance of rupees 20,000 from the respondent. Along with the main petition, petitioner has filed IA number 2, seeking interim maintenance of rupees 8,000 per month from the respondent during the pendentality of these proceedings. As she has no source of income to account their livelihood, the respondent has registered the claim for interim maintenance of the petitioner on the grounds as stated above. It is the case of the petitioner that her marriage with the respondent was solemnized on 29/6/1978 in the house of the respondent at Kora village, Tumkur Taluk, and after the marriage, she led life with the respondent for a period of 3 years. And out of their wedlock, a son by name Shiv Kumar Yamar was born. Thereafter, the respondent and his family members started ill-treat the petitioner and neglected to maintain her and the respondents throughout the petitioner from the house, and as such, she has taken shelter in her parents' house. The respondent has contended that after marriage, the petitioner stayed with him only for a period of 4 months. Thereafter, she started quarrel with the respondent and his family members for one or the other reasons. In that regard, Panchayat was conveyed, but the petitioner has not changed her behavior. Thereafter, the petitioner entered into an agreement with the respondent, stating that it is not possible to continue her relationship with the respondent and she is ready to live separately. It is pertinent to note that.
What do you say?
Please.
Petitioner has since from after the marriage, within 1 year, they are living together, thereafter she is living separately, but she is independently, she is living with her parents, now she's parents is alive, she is not that's why she is living independently,
So right from 1987.
87.
1987 till now, till 2022, you have not filed any application.
No, madam,
And you don't even say what has happened, what is your status? Why are you staying separately? Were there anything? And nothing has been stated.
but she not stated.
No, when he says about this, the settlement that is entered between the parties, what are your instructions on that?
I take instruction, on 2 days, take instruction.
No, this is an interim application. Let the court decide on a full form. Prima facie, there is a material to show that right from 1987, that's also your case also. We'll allow this writ petition. The court shall consider.
At least interim maintenance, she want to implement.
Let the court decide this application finally on all that, what is happening, why you both of you are not staying together.
On 2 days accommodation, I will instruction, that's why. 2 days, day after tomorrow.
Close this matter on Saturday
Much
at the request of Land Counsel for the response. Yes, next.
Cell number 14. Muni Reddy, ML for petitioner, KP Bhuvan,
Here for respondent, my lord.
respondent.
Give that. Yes.
My lord, I will file objection, my lord.
Yes.
Next time.
You will file or you are filing?
Will file objection, my lord.
What objections you will file? Let's see. What is impugned order?
Impugned order is a grant of maintenance, my lord.
You are for the wife or husband?
I am for the husband.
How much is granted?
10,500, 10,000.
10,000 is granted. What is your occupation?
I am a supervisor in fair shop, and my salary is 10,500.
Apart from that, any other income?
No, madam.
Have you filed your statement of assets before the trial court?
Please. And
No immobile, mobile properties?
no, madam.
Please come to the order.
At page, in page 20, my lord, paragraph 10. I'll read my. Learned counsel for the petitioner argued that the earlier petitioner was working on another.
That is engineer and earning 75,000 per month.
No, ma'am.
Stays in his own house.
That's their allegation, ma'am.
No, that's what I'm reading.
Finding is at page,
Children are there.
no, ma'am. My lords may come to page 20, paragraph 10.
Please read.
Learned counsel for the petitioner has argued that the earlier petitioner was working in another company wherein he was earning that amount, and now he is only working as a storekeeper and earning rupees 10,500 per month. The petitioner has produced his convocation certificate show that he was done Bachelor of Arts degree and is not engineer. On looking these documents, the affidavit asserts the liabilities and there is no material to show that the respondent is having any income of her own. Respondents are also not placed any material to show that the petitioner is an engineer and is earning 70,000 per month. The document produced by the petitioner show that petitioner is not engineer. Petitioner document, the documents produced by the petitioner also show that in 2 months there are credits of 10,500 each of his account. There are no much clear material to show that petitioner is earning 70,000 per month from salary, and also that he has a real estate income as stated by respondent. However, it's duty of the petitioner to make arrangement for maintenance of his wife who is residing separately and who is not having any income of her own. Though the capacity of the petitioner to pay 25,000 per month to respondent is not established, at the same time requirement of respondent of maintenance is
Yes.
also.
What do you say?
That week's time may be given, senior RP matter, my lord. Senior has to appear. my lord. Because my lord, salary of rupees 17,000.
Where is that? He has filed his statement of assets and liabilities. As per that, he is earning 10,000. Court also takes note of it. Court also observes that there is no material to show that he is earning 70,000. Then why, on what basis court has granted 10,000?
My lord, they have not filed any assets and liabilities.
You have not filed?
I have filed. It's
Where
there.
are they? Do you have a copy of it?
No, ma'am. No, not me.
I will file objection, my lord.
You are not even aware that have you filed whether the statement of assets and liabilities are filed?
It's filed, ma'am. It's there, ma'am.
For this matter. On 16th of October. By the time both the parties shall place before the court the statement of assets and liabilities filed before the trial court. Yes, next.
Number
Please.
15, Jayasima Kirti. For petitioner.
Appearing for respondent, my lord.
The
Kindly place
petitioner.
time for objection. my lord. Kindly place time for objection, my lord.
Any interim order is there?
Yes, my lordship.
At the request of the counsel for the respondent, post this matter on 22nd of October. Interim order earlier granted is extended till then.
Obviously.
Motion cell number 16, Sidmalappa PM for appellant.
Appearing for the petition, your lordship. Your lordship, the respondent is dead, your lordship. The respondent is dead, your lordship.
First of all, notice is also not ordered to the respondent. For that,
So-
first, it's coming up for admission.
Yes, your lordship.
First, the court has to hear you. Then we will think any notice is required. For
Your lordship,
for dismissing the appeal, whether the respondent is there or not, doesn't matter. You can take appropriate steps before the trial court. So let your senior come and argue. We'll pass over the matter. Ask him to come. Yes, next.
Cell number 17. SCA Sudin.
Appearing for respondent, my lord. Appearing for respondent.
Well, in this case, the dispute is with respect to survey number 56 and 57.
Is that you want to say?
My lords, I have the instruction that there's no objection, there's no possibility of settlement, my lords. We are ready to argue the matter, my lords. My lord, senior is not here, my lords. Kindly give him any date.
Asked for a settlement?
In the last occasion,
It
a
is submitted
proposal
by
was
the
made.
counsel for the respondent, the settlement talks are going on. You only said.
No, my lords, they have offered me.
In fact, we had sought for the settlement because The site purchased by the appellant is in survey number 56. The site purchased by the respondent is in survey number 57. There is overlapping. In fact, they proceeded with the construction day and night. They completed the ground floor. The ground floor, the slab was put. So at that time, the court did not interfere because the construction had completed.
We'll have it day after.
That is the reason the settlement was
We'll have it day after tomorrow,
day after tomorrow,
Saturday,
Friday.
Friday. Yes, next, at the request of learned counsel for the respondent, holds this matter.
In
day after
fact,
tomorrow.
I had told my learner friend to see the possible, because see, if they pay the cost for the site which my client has purchased, that is sufficient. We will leave our interest. In fact, I told them, I don't know why. Let the senior come, then we will discuss. Much pleasure.
Yes.
Sorry, my lord. Serial number 14, interim order, my kind.
Wherever interim order is there, it will be extended.
I'm grateful.
Yes. 18.
Cell number 18.
For applying, praying for a week's time.
KH Chimaya.
Praying for a week's time, Lord. Senior is in out of station.
In the
Requesting to have it on, out of station, my lords.
There is a stay.
There is no stay.
Lords, stay application to be
at the
considered.
request
In
of
fact, not the, for the trial court, they have adduced the evidence. All that, not the impugned audit is said that. Now the disputed property, which is not the subject matter of the suit, not it requires evidence. Therefore, the trial court has not
Lords,
rejected. the
that
interim.
proceedings
There
has
is
to
no
be
stay.
stayed, my lord.
There is
And
no
the trial court is proceeding, you cannot have any objection. At the request of learned counsel for the appellant, post this matter on November 12th.
My lords, I request either my emergency is there, my lord. Requesting to have it on 27th or 26th, my lords.
No shortage.
My lords, at least first week of next month, my lords, because some emergency.
The matter reaches every time you people want time, and again you want a short accommodation. Post on 21st of October. Yes, next.
Cell number 19.
Your lordship, serial number 19, I appear.
Cell number
Respondent
19.
1 and 2. I seek for a short passover, your lordship. The matter can be-
Passover.
Cell number 20. Urgent. Cell
Lordship,
number
I request a
21.
Passover. Day tomorrow, and tomorrow, my lord. Not tomorrow, we'll have it on Saturday, 19th, on Saturday, 19 item.
21st.
Yes.
Cell number 20, urgent 21.
I am for the appellate's
Mr.
plea.
Reddy.
Matter arising out of Karnataka Protection of Interest of Depositors in Financial Establishments Act.
Yes.
Subject matter, please, my lord. Subject matter of the present case is a piece of land measuring 3 acres. 3 acres, 6 guntas.
Where is the counsel for the respondent?
ಅವ್ರಿಗಿನ್ನು notice ಆಗಿಲ್ಲ. First time.
Oh, name is there, Vidyulata. No, what is the name? Bipin Hegde.
21.
21, Bipin Hegde. Counsel for the respondent.
Maybe first time it is coming up before this one for admission.
21,
Yes.
3735. Look at the cause title. I mean, the cause list. Caveator, what is that? CR means what? Caveat, you have served the papers on the caveator?
I will serve it, but I was not knowing it.
There in the.
I did not receive it at all.
No, in the cause list, it is mentioned.
If
There
it
is
is
a caveat.
mentioned, but the thing is, after making the interim order of attachment absolute, this is the only property which we have, ancestral
No,
property.
we'll pass orders now. What will happen is, when there is a caveat, if there any order is passed now.
I understand.
So
I-
please, sir, I'll
understand.
take it up on Saturday,
Saturday sitting.
whenever you want, but not.
ಇಲ್ಲ
today.
ಇಲ್ಲ Saturday ತಗೊಳ್ಳಿ.
On Saturday,
Saturday.
post this matter on Saturday. By the time the counsel for the appellant shall serve the copies of the appeal memo on the caveator.
Cell number 22, urgent
I may be-
23.
I may be permitted to take the phone number of the advocate.
Yes,
I will take it.
22,
22, urgent.
adjourned, not informed to you.
they never informed me. But they also filed one more
Along.
petition along
But
with.
that's what they said.
When
Along that MFA to be
short date may be
posted.
quickly account.
When is it posted? 2110. Yes,
Constructions are going on.
yes,
Some difficulties I'm facing.
yes, next.
23. Money and KBS. KBS Money and
No representation on behalf of the appellant pose this matter on 25th of October.
Case number 24, urgent, 24, BO Chandrasekhar. 24,
I am for the appellant. I am for the appellants.
Yes.
It's also pertaining to Karnataka protection of interest of depositors in financial institutions.
Yes. What is the order? Let's see.
Let's say. The matter pertains to agricultural land situated at Kudligi Taluk, Ballari district. This is the only property and this is the ancestral property of ours. We are the objectors before the trial court, before the special court. We are the objectors.
What is your relation with that company and the directors?
That is the thing. Let's say. My father's name is D. Nagaraja. D. Nagaraja is my father. He has illegally executed sale deed on 19/1/2011 in favor of one R3 Madhav Reddy. R3.
In 1/2011.
19/1/2011. It is an ancestral and co-personatory property. My father has executed a sale deed dated 19 in favor of R3. R3 is an independent person. Madhava Reddy. R3 is an independent person. Now the case ought to be made out by the competent authorities. Madhava Reddy was running a Maitri plantation on the R2. He was running this horticulture private limited company. He has collected deposits from the farmers and he has misused it.
So this is sought to be attached now. This is attached.
This property is sought to be attached. This property is sought to be attached.
So the sale is in the year 19/1/2011.
Yes, my lord. During
Thereon, what these family members were doing?
there was no partition. Right from 84-85, the record of rights indicate that it is Pitrarjita Asti, exhibit P1.
Have you filed a suit?
I have filed a suit and there is a decree stating that
Was the suit filed?
the suit was filed, please my lords. I have the judgment copy in my hand.
You can tell the date.
Suit was of the year 2020, 80 of 2020.
When this proceedings are started?
This is the judgment copy. Before prayer, long prayer to commencement of these proceedings. Proceeding was filed on 29/12/2023. 20 suit haki, a sale deed nam tandege, it is binding only to the extent of his 1/3 share antagide. It is not an afterthought prior to institution of this.
Suit of the plaintiff is by decree. The plaintiffs are together entitled to 2/3 share in the suit scheduled property. Who are
Say-
the plaintiffs?
We are the plaintiffs, objectors.
The objectors are the children of
Nagaraja,
Nagaraja.
who has illegally sold the property to this R3. Madhav Reddy. Minority of one objector was a minor as on that time, as on the date of sale deed. Minor iddu Pitrarjita Astina marbitu.
Respondent is Madhav Reddy. Madhav Reddy contested it?
Madhav Reddy did not contest, he escaped. I am at this thing.
Your father will be there, he will anyhow not contest it.
Well, it is left to my father. He has virtually, we are on streets now. That is the only property we have. And more than that, please, my lords, it is filed entry order admele 6 varsha admele aagtare idana. 6 years. They took 6 years. Interim attachment order on 2017. This petition was filed on 29/12/2023. 6 years. Outer limit is only 45 days. Jotege, my lords, when I file a petition before the special court, showing some interest in the section 12, any person having an interest in the attached property can file objection anteli. But the trial court did not accept my objection or reject my objection. Lordship may kindly see the operative portion of the order. Nanna objection accept agide, reject agide, straight away you go and sell the property.
No, is it, why not, why can't, what is the material to show that it is a ancestral property, but not the self-acquired property of Nagaraja?
ಇದೊಂದು ನೋಡ್ಬಿಡಿ ಇಲ್ಲಿಂದ ಇದೆ 85-86 ಪಿತ್ರಾರ್ಜಿತ ಅಂತ throat because it is an appeal I could not file annexures. I have adduced 85 ದದು ಅಲ್ಲಿಂದ ಶುರುವಾಗಿದೆ.
Issues Pitrajita.
ಪಿತ್ರಾರ್ಜಿತ ಅಂತ ಇದೆ 12
Nagaraja Pitrajita.
ಕಾಲಮ್ ನಂಬರ್ 12 ನೋಡಿ 12 ಪಿತ್ರಾರ್ಜಿತ ಅಂತ ಇದೆ ರೈಟ್ ಸೈಡ್ ಟಾಪ್.
Top, she said.
Right. Throughout, please, my lords, till the date of filing of the suit.
So please come to the order impugned. What did the court say? Let's see.
Lordship, I'll point out, please, my lords.
Yeah.
Page 29.
29.
Page 29. Page 29, para 20B. On the other hand, along with the objection statement, objectors have produced RTC extract for the years 84, 85 to 2019 to 2020 as per annexures R1 to R5. Copy of the sale deed dated, that is the sale deed, my father's sale deed. 19/1/2021 as per annexure R6. Certified copy of the judgment decree in so and so. And certified copy of the petition FDP proceedings 4/2023. And order sheet and also commissioner warrant with report exhibit R9 to
Was the
R12.
property attached?
Please, my lords. Property was attached, please, my lords. It was attached on 15/6/2017, interim order of attachment government. We had no notice at all.
So, no,
Please.
no. The suit is not filed as on the day.
No, it is not filed. It is not, we were not aware of all these things at all. Only when this miscellaneous petition was instituted, after 6 years from the date of attachment, that is 2023, we came to know about this and we, bona fide, we approached the trial court and filed our objections. The minimum thing, please, my lords, the trial court has not even gone to the extent of verifying these documents at all. Pitrarjita anta throat bandide son. Entire thing is ancestral property. No partition in our family. As on the date of sale deed, the sale deed indicates that the minor is not even represented by natural guardian at all. Idu one asti hogibitre, we are on streets, please, my lords. It is an agricultural land. Well, page 36, lordship, may kindly see. Page 36. There is a finding that my father was the actual owner of the property in the finding. Para 23. Para 23, page 36.
Twenty-two E, please come to 22E at page number 34.
In the light of the argument addressed, the materials placed.
Para number 22E at page number 34.
22E.
Yes.
As already stated, despite the service of notice, the respondents have not opted to appear before the court to show any cause as to why the interim order of attachment passed by the government with regard to the petition should not
What
be.
is this?
My father, I am not the respondent, I am the objector there. My father, he has gone away, he has sold the property and gone away. ಅವ್ರಿಗೇನು ಮಕ್ಕಳು ಭವಿಷ್ಯ ಏನಿಲ್ಲ. ಮೈನಾರಿಟಿ ಟೈಮಲ್ಲಿ ಕಾಪರ್ ಸಿನರಿ ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಿಬಿಟ್ಟು page 36, lordship, may kindly see. Page 36. 36 ಅಲ್ಲಿ my father is the owner ಅಂತ finding ಬಂದ್ಬಿಡಿ. Para 23. In the light of the arguments addressed on going through the sale deed, produced both of clear that the father of the objector Nagaraja being the owner of the scheduled property executed. How can he become the exclusive and absolute owner, please, my lords? When the entire revenue records indicate that it is Pitrajita Asti. Adu, now we have sought for release of the attached property only to the extent of our share, 2/3 share. Rest of it, we have no objection at all. As declared by the civil court in the partition suit.
Please come. Agreed with the orders passed in miscellaneous number 22 of 2024. Dated 6th of August 2024. The appellants are before this court. Appellants are the objectors. The property which is the ancestral property of the appellants was attached by the special court. It is the case of the objectors that the property that is in survey number
262-B-2. 262-B/2.
If you look at, look at the suit, no survey number anywhere. No, in the suit it should be there. It is stated that the property in survey number 262/B/2, an extent of
3 acres, 6 gunta.
3 acres, 6 guntas is an ancestral property. The father of the appellants, Nagaraja, had sold the property in the year on 19/1/2011 in favor of R3, that is Madhav Reddy. When one of the appellant is a minor or both are minors?
One of the second appellant was the minor.
Second appellant was a minor. As it's an ancestral property or the RTC extract shows that it's an ancestral property. And when they have the right and the property is not partitioned, the father has no right to sell the property. It is stated that when they came to know about the sale deed, they have filed a suit for partition. That is OS number 80 of 2020, which came to be decreed on 12th July 2022, where the court has said that the appellants are entitled for 2/3 of the share in the sue scheduled property. When the property is attached in the year 2017, how are you not aware of it?
Well, it was, we were not aware, government gazette notice there, they say that there was a gazette notification.
It is submitted.
We were
that-
not aware of it at all.
Submitted that they are not even aware of the attachment that is made in the year 2017. Thereafter, when they filed an objection before the court, bringing to the notice of the special court about all the events that had taken place and their right to the property without considering the same in the proper perspective, their miscellaneous application is dismissed.
Yeah,
Next para. This
mis-
court, having heard the learned counsel for the appellant.
Miscellaneous application is allowed.
The miscellaneous application, without considering their applications, the miscellaneous application is allowed. Land counsel submits that, and the attachment is made absolute now.
Yes, yes, yes.
And the attachment is made absolute. Having heard the arguments of land counsel, this court has perused the order passed by the trial court, passed by the special court. The attachment is in the year 2017. And the court has also perused the RTC extracts and also the judgment passed with the trial court, which shows that the property is an ancestral property. And the second appellant is a minor as on the date of the execution of the sale deed in favor of Madhav Reddy. A perusal of the order shows that the trial court has not considered all these issues. Considering the same, there shall be stay of all further proceedings. Pursuant to the order dated
6/8/2024.
dated
6/8,
6/8/2024
2024.
till the next date of hearing. The appellant is permitted to take out notice, the hand summons on the counsel appearing before the trial court to the respondents and shall mail memo to that effect. The registry is also directed to issue notice. Post this matter on 21st of October. Yes.
Great.
25, 26 urgent, cell number 27. Kashinath JT.
Petitioner.
Yes.
In the first matter, I am the petitioner. And
Where is the other side?
Sandesh P. Nadiger.
Will you pass over?
some other time, Since
Stay in your
last
favor?
3 days, 3 hearing, my lord, they're not appeared.
They have not appeared, let's see.
Last date also. And they are not even served the petition copy, my lord, the connected matter.
You have an interim order in your favor?
In my, my lord, the interim order and this court, my lord, directed to deposit, my lord, the 1 year period maintenance as per the trial court order. And directed the respondent to find out the job since she is having an engineering qualification. Since she was working, my lord, at the time, but she has.
No, you
suppressed-
have an interim order or not? It is there, interim
Yeah,
order is
It's,
there.
it's,
No representation for the respondent. Respondent, interim order earlier granted is extended till the next date of hearing. Holds this matter on 5th of November. Yes, next.
Chair number 28 for dismissal. Dhanalakshmi K. Dhanalakshmi K for appellant.
Yes, give that. On 9/9/2024, at request of Land Counsel, the appellant, these matters were directed to be listed on 17/9/2024. And this court has also made it clear that no further adjournments will be granted. When the matter came up on 17/9/2024, as there was no representation on behalf of the appellant, the matters were directed to be posted for dismissal on 18/9/2024. Today, when the matters are listed before the court, there is no representation on behalf of the appellant. Appellant, it is submitted that the appellants have questioned a remand order made by the court or the arbitrator.
District Court.
By the district court. District court, and right from 2015, in view of the pending MFA, the matter was not heard concerning the same, and the fact that the appellant is not interested to pursue the matter, and it's an appeal of 2015. The appeal is dismissed for non-prosecution.
Chair number 29,
Grateful, my lord.
Kumara KG.
Petitioner, my lords. Plus, my lords, petitioner filed, my lords, another, my lords, 2 writ petitions.
Respondent.
Yes.
My lords, against the, my lords, it's separate IS, my lords. That may be called along with, my lords, other writ petitions.
It is.
My lords, there are other two writ petitions are pending, arising out of same parties, between same parties, against the separate applications, my lords.
Yes.
May be called along.
Post along with, give those numbers, right on a paper.
4340 of 2022.
Right, post along with the connected writ petition. 22nd of October. Yes, next.
Chair number 30, Gekar Shetty.
See any what happened earlier occasion. There is no representation on behalf of the petitioner, Land Counsel, but the respondent is present for dismissal on so and so. There is no representation on behalf of the petitioner. The matter is directed to be listed for dismissal today. Today also there is no representation. Accordingly, it appears that the appellant is, petitioner is not interested to pursue the matter. Dismissed for non-prosecution. Yes.
Cell number 32, Rupesh Kumar S.
Blood for the respondent.
Yes.
MH Prakash for respondent.
The counsel, yes.
Milord, senior is arguing another matter and we have seek a short accommodation, Milord.
Appellant is not there, you're for the respondent, I think.
Yes, Milord, we are the appellants in one connected matter, Milord.
I think already the vacation mood has come to the advocates. All adjournments in every case. Pose these matters. on October 22nd at the request of learned counsel for the petition. Yes, 33.
Cell number 33,
Yes,
Vinod Gowda.
no representation for dismissal tomorrow. Yes,
Cell number 34,
it's already adjourned 34.
Responded by me, Your Honor.
34 is not adjourned.
It's not adjourned, my lord. Not it's not adjourned. There is an inordinate
lord,
delay of 393 days, my lord. I
Who
want to-
wanted adjournment in the morning?
I'll seek your adjournment, or respondent seeks your adjournment.
Oh, you want to file,
Please, my lord.
then counsel for the.
393 days is.
My lord, my submission is this has been petition argued by the ex parte order passed by the family court, Mysore, even without serving notice to the husband.
On that he wants to, he's entitled to file his objection.
Please, and my application
Number
for
1
stay.
of 24 is filed to condone the delay of 390 days. Then counsel with the respondent submits that he'll come up with objections. Pose this matter on.
ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡು ಅಲ್ಲಿ ವಾರೆಂಟ್ ಆಗಿದೆ ಸರ್ ಪ್ಲೀಸ್.
If you want time for filing counter, you shouldn't.
Any short date may be accommodated, my lord.
Pose this matter on 30th of September. Till such time, they should not press on the execution.
Great.
Next,
cell number 35. 35,
notice to the
Ganapati.
respondents,
Kindly pass on.
notice to the respondents on a delay petition.
cell
But you-
number 36.
Yes,
I am for the respondent.
Ranjit Gaur.
In this,
36.
the other side will be directed to give me the copies.
Serve him the papers, then counsel for the petition is
So
directed
that
to
I
serve the papers on the
Officer
counsel
served.
for the
let the,
respondent. Pose this matter. Is there any urgency for you?
Urgency is not,
Huh?
I'll pay the
No
amount.
urgency for you?
No.
Pose this matter on 15th of October.
No, it's not 15, any other day.
Some 15th of, even October, you're not ready.
No, even before that or after that, because 15th I have matter in Pola,
Yes, 22nd of October.
not interim orders may be extended.
Interim order earlier granted is extended.
yeah, a conditional stay was granted by this honorable court
I'm paying the.
to deposit
I'm
about 2
depositing.
lakhs.
It seems he's depositing it.
I'm depositing.
Yes.
Cell number 37, Praveen S.
For the petitioner in this case, my lordship.
Respondent in
this case, my lordship, we have abided by the orders of this honorable court in granting visitation to the respondent husband on all occasions, my lordship. However, my lordship, there's one submission, there is some arrears of maintenance pending from the respondent side, my lordship.
That he has to pay, he will pay. Yes, how, what are your instructions, Mr. Counsel?
My lordship, we were instructed on every weekend to grant instructions,
Yes,
to grant.
I'm asking him. Yes. Counsel for the father.
I appear for the respondent in this case, my lord.
Yes.
My lord, the three visitations were allowed. And he exercised the visitation right, my lord, but still he is in the, I don't know whether any positive efforts have been made by the petitioner as a respondent in this case. Insofar as the child's counseling is concerned or child's improvement is concerned. So that is one thing is in our mind.
He is there in the court.
He is there in the court, my lord.
The petitioner is also present before this court, my lordship.
So advocates are not there. Only parties are there. How it happened?
Yeah, man, this time I met Miss Ann 3 times. 1 week I couldn't meet because I was unwell, but all 3 times I met my child.
So it went on well.
Yeah, I mean,
So please don't tell me some a perfection point of view. You have to tell like how it went on compared to the other times. Now how
yeah,
it
compared to other times it was better.
was good.
Uh,
Yes.
But again, he's still
It will
not
take
ready
time,
to.
It will take time. It will not happen overnight.
Hmm.
So now at least he is coming, you are able to exercise.
Yes,
So once it goes on, then what about the arrears of maintenance?
I've already started paying long back.
What
Every
are the
month-
arrears, Mr. Counsel?
Present month, my lordship, it is.
Every
the
month I'm
arrears are
paying,
close
and
to a
I've
lakh.
already paid the.
1 minute. When?
There is arrears for close to 1.5 years, my lordship. That's about 7,000 rupees per month.
Ma'am, I've already started paying. And apart from that, even the school fees, the first installment also I paid.
Mm.
Second installment I was about to pay, but she paid already. So the third installment I'll pay. So that I'll continue paying on
No, no.
Yeah.
the school expenses, what was the direction that you have to pay the entire school expense?
No,
50%,
50%
my
of
lordship.
the school fee.
So 50% of the school expenses, if she
Yes.
has already paid something,
Right.
so whatever is that, you know that what is the amount? If she has already paid, you pay it to her.
Yeah.
50% you're supposed to pay.
Yes, yes.
In that amount, whatever is less, you pay to her.
Yes, yes.
But that is one.
Hmm.
Then the arrears, why he is not able to understand what is that?
My lordship, from the date of the petition, the orders were from the date of petition till the date of realization, my lordship. But
When
he's
was
only
petition-
paying the
When was
present.
the petition filed?
My lordship, the petition was filed in the year 2022, my lordship.
2022.
Yes.
Which month?
My lordship, I don't have the data with me, but I'll file a summary of memo of calculation, my lordship.
Next time, but when the matter comes up next time, let him continue to pay the amount. With regard to the arrears and all, you come up with a calculation memo.
I will do the
And,
needful, my lordship.
The school fees, 50% of it, if the wife has already paid, you give it to her, that amount.
Yeah,
The
I'm
other
already,
50%.
no, she has not paid 50, I already paid the first
That's
installment.
what if
Whatever is
50%
there,
you
we'll-
pay,
yes, yes.
if it, what is that? 50% school
Totally
fees.
4 installments.
Uh-huh.
It's totally 4
So
installments.
two you
ma'am.
are paying, two he is paying.
Yeah.
Yes.
So you have,
Already paid one, she already paid one installment.
okay, then you have
Only,
to pay
yeah,
another
next time
installment that
I'll-
you will pay.
yeah,
The
yeah.
fourth one you will pay.
Yes, oh, my third one I'll pay. I mean, she already paid the second installment.
Yes. And now you're continuing to pay that amount,
Yes.
that monthly maintenance.
Yes, I am already paying.
And next time when they come up with the calculation from the date of petition at that point, amount, then if it is, the amount is more, then we will fix
Sure.
you know, like, they're giving you some time
Yeah.
and to pay that amount.
Yes. ma'am.
So
Please.
what about the visitation? How is it going on?
It's going on well, ma'am.
So
From
let
my
it
end,
go.
I am putting in efforts.
Hmm.
But my only request is like you had, you know, according to, I mean, you had ordered that by Wednesday it has to be informed. But I was getting the mails only on Friday midnights and on Saturday. So, you know, it
When
will
is the
be
visitation on Saturday?
Sunday.
No, then.
So
do
it
it
Yeah,
by
ma'am, I'm
Wednesday.
difficult
sending
for
it.
me, ma'am,
Sometimes,
like,
it
plan
goes one day
everything,
too.
right? Even previous visitations also were the same. This problem was the same. He
Yeah,
never used
ma'am,
to stick
ma'am,
to the,
even-
you know,
No,
visitation properly.
No, it is like when an order is passed, it
Yes.
has to be in accordance with the order.
Right, right.
No, when the court says it has to be on a Wednesday, you have to, at latest by Wednesday, you have to inform.
Yeah.
There are no other, for sending a message, I don't think you require any, special effort is required.
No, ma'am. So I've just, every time I'm sending a different
It has to
location.
be by Wednesday.
So even sometimes even one was like the last visitation, I had sent an email and she sent me confirmation also that morning we'll meet. But just one day, like Saturday evening, she sent a message that I will meet in the afternoon. That is Onam. So I had already planned the activities, but still because of
Because
for her
I'm not getting
convenience, I was ready.
confirmations by Wednesday,
No.
I
No, but-
also have to make
but
my own
then-
plans.
But still
Court do
I,
not want to hear any kind of
Yeah.
complaints.
yes,
So come up with solution, how you want it to be.
Yes, ma'am.
What has happened, so happened.
yes.
So from now onwards, on every by Wednesday, he'll update. Even from your side also, the same, the response should be at an earliest. Follow it. And we'll let this be continued for some more time.
Yeah.
We'll have this matter on,
One more request, if I can get more time, because it's just 7
at
to,
this time. Looking at the, that the way the things were going, let's not, push it, it's too early for that. We'll have it till, we'll pose this matter on October 29.
An earlier date may be granted, my lordship, for filing the memo of calculation.
That.
An earlier date may
You
be
can
granted.
file it just a month, October 29. In between, you will have, like how the earlier arrangement is. And then on that day, we will see, like any more, we can, you will get more time for that. And most important time is, thing you have to remember is, whatever of the things, don't react.
Yeah.
And let things go on well.
Yeah.
And don't, both of you don't have to fight with each other on anything. Now that will have an impact on the child, and you will be the one who is going to pay for it. Is it not?
yes.
Then you will say that he'll not meet you. So have some patience for some time. As per the order dated 23/8/2024, it is submitted that the father had exercised the visitation and the visitation went on well. Both the mother and the father are present before the court. They have stated about some lapses on side of both the parties with regard to the informing the other partner about the time and all, except that it appears that the visitation has went on well, and counsel appearing for the mother submits that father has to pay the arrears of maintenance, and he'll come up with a memo, like what was the amount due and how much he's supposed to pay. Land counsel appearing for the father submits that father, as per the directions, has been paying 50% of the school expenses, and now, as of now, is continuing to pay the maintenance to the maintenance. And once the calculation memo is filed, basing on that, the further orders can be passed. It is submitted that the father may be granted some more time, as he's meeting the son only on a Saturday between 10 a.m. to 1 p.m. If some
Sunday.
more time is granted, it's a Saturday or
Sunday, Sunday.
Huh?
Sunday.
On Sunday between 10 a.m. to 1 p.m. If some more time is granted to him and the visitation may be extended, he would be able to establish the bonding with the child. Next para. Considering the interaction this court had with the child, with the parents and the child, and also how reluctant the child was earlier to meet the father, at this point of time, this court is not inclined to extend the time. If this arrangement goes on for some more time, and basing on basing on the bonding and how the things are going, in the interest of the child, further arrangements can be made. In that view of the matter, this court is passing the following order. What are the dates? 22nd, 29th, 22nd, 29th of September, and then 6th, 13th, 20th, and 27th of November. The father shall exercise father is permitted to meet the son between 10 a.m. and 1 p.m. along with the mother. And next, other 2, 3, 4 conditions, same conditions also this incorporate in this. Next, another clause is, by the next date of hearing, the memo shall be filed with regard to the arrears of maintenance. Pose this matter on 29th as part heard.
Much obliged.
Oblige, my lordship.
Thank you.
Thank you.
Yes.
Cell number 38.
Apologies, my lord. Serial number 23, the list collapsed from 13 to 24, my lord, were appellants in this matter. By the time senior could enter, it was
Which matter?
serial number 23, my lord.
What has happened?
My lord, it was called out from 13 to 24. The
No,
list,
what happened? I'm saying, what happened to that matter?
my lord,
23.
it's for admission.
That is on 25th. then, no?
It's on 20. My lord, kindly have it next week, my lord.
Next week, 23rd, item number 23. Yes, next.
Grateful, madam.
Yes.
Cell number 38.
Yes.
This matter not appear for the petitioner. Or last date of hearing, by mistake, my colleague, two DDs were given. One was in the name of the register, and another one was not in the name of respondent. That the register depositing before this court, he made a submission that.
Yes.
Then,
Docket.
if that DD is returned, I will ask my client to.
The petitioner has placed 2 demand drafts for an amount of rupees 3,80,000 before
yes,
this
ma'am.
court. This court is of the view that an opportunity shall be given to the petitioner to put forth his case. It will be in the interest of both the parties.
Yes, ma'am.
In that view of the matter, the petitioner shall hand over the demand drafts of an amount of rupees 3,80,000 to the counsel for the respondent. The party is also present before this court. Accordingly, order dated 3/1/2024, restored.
Yes, ma'am. That two demand drafts were handed over. That was one is in the name of register as per the order of this honorable court, earlier order. That can be modified, and I will.
It is restored till the next date of hearing. Ask them to, change this before the website also. Then you ask them to make this. This is restored. Following the order dated 3/1/2024.
3/1/2024, I suppose.
Order.
That is the interim order. I supposed to deposit 2 lakhs before this honorable court. But last date of hearing.
Understood. Is restored. No, now what is the amount in favor of the client?
3,80,000.
1,80,000 was given, my lord. 1,80,000 has been released by her.
One lakh
to check.
80,000 is in the name of the client.
Yes.
The other
And the
1 lakh,
rest was in the
other
register.
amount is 1 lakh?
2 lakhs.
2 lakhs. 2 lakhs is in the name of the registrar.
Register, my lord. Now if she handed over that DD to me, I will ask my client to, my lord, the
That's
pay it
with
is-
you, that's with
Yes,
you.
it's with the respondent, my lord. We'll return the same thing and they may do the needful.
Yes.
And my lord,
It is submitted
But-
that on the last occasion, this court has observed that 2 DDs for an amount of rupees 3,80,000 are handed over to the council appearing for the respondent. And council for the petitioner submits that by oversight, one of the DD is in the name of the registrar, the High Court of Karnataka. He submits that, no, the other, one for an amount of rupees 1,80,000, the DD is in the name of the respondent wife. And 2 lakh DD is in the name of the registrar. And counsel for the respondent submits that, no, today she will hand over the same. It is
2
there
lakhs.
with you.
We'll hand it over in a week's time. yeah.
It is
She's not-
stated that within a week's time, they will hand over the same to the counsel for the respondent and then counsel to the petitioner. And the counsel for the petitioner submits that by which date?
by next week, my lord, so after handing over, my lord, I will ask him to take, my lord, DD in her name, and my lord, I will hand over.
Can be an exchange.
By 30th?
My lord, so
If you, immediately, if you give
Yes,
to
yes.
him so that it will facilitate.
I will ask him to, my lord, bring
Post
the
this
DD in
matter
her
on 30th, by the time, the
exchange.
30th,
Yes,
by the time the DD shall be, they shall hand over the DD in the name of the respondent.
because I have to cancel it and, my lord, again, I have
So
to
it won't
bring it.
happen 30th. Then
Lord,
if it is not, then it has to go beyond vacation.
My lord, 30 should be fine.
No, anyhow, we'll post it till 30th, on 30th. By the time you make efforts.
Yes,
if
my
it
lord,
will
my
not-
lord, as a, if
Try
she,
to give it by tomorrow.
Today only we'll try to do it.
Today, so that they'll have the time to cancel
And-
it. Then. Yes. Next,
interim order is there.
interim order earlier granted is extended.
Sale number 39 urgent 40. Sale number 40 Vardhaman V Gunjal.
Where is
Yeah.
the counsel for the respondent?
Ashish Agarwal party.
I'm the respondent party in person.
Where is Mr. Vardhaman?
VV Gunjal.
Pass out this matter.
Yes, Your Honor, I
Have the phone number of the counsel?
but Your Honor, they do not respond on the last occasion also when I,
Just send a
I
message.
will just try,
No, send a message. Matter is passed over.
yes, Your Honor, I'll make a WhatsApp.
We'll take it up after lunch.
And I
Yes, ma'am.
filed my memo, Your Honor. My individual memo I have filed, they have not filed it from there.
Have you not communicated to them?
Your Honor, it so happened that the mediation was on the 4th of this month. On the 5th evening, within 24 hours, I had filed my side of proposal, Your Honor.
But
They
have not
filed,
come back,
Your Honor.
but they have not come back.
They reverted on the 16th, Your Honor, when I had already commenced my journey for Bangalore. I travel by bus, Your Honor. It takes me 24 hours.
So, are the terms and conditions of the settlement, have they accepted? Have you gone through that?
I have gone through that and I have filed that also, Your Honor, yesterday.
You're
But-
fine. Please tell the court, is there any difference in your?
Yes,
both of-
Your Honor, there is a difference.
What is
And
the difference where you are not agreeing?
Your Honor, my initial proposal was of 5 lakh rupees, which Your Honor had directed me to be a bit more reasonable. So I made it 2.5 folds, Your Honor. I made it 13 lakhs. Now, Your Honor, they, on the date of mediation, Your Honor, they had allegedly claimed that there some imaginary.
No, that is not, let's not go into that. Now, what they say, what they have
They
forwarded to
claim
you.
that the jewelry which was of worth 2 crore rupees before on the 4th of September, it has now shrank down to 1 crore, Your Honor. So it is a statement made before the honorable court.
Oh, are they still sticking to that jewelry?
Yes, Your Honor, they are still sticking to that and they are possessing one property document of my father, which was there with the petitioner's father. So in my proposal, I had just stated that in order to clear off all the litigations and cross litigations, please hand me over my, in the clause number, I have mentioned that please hand over that land, the property document, patta book, Your Honor. So they have claimed, because it is clearly stated that if there needs to be a FIR registered for the loss of, it's a valuable instrument, Your Honor. So
if I do that, I'll have to mention the fact that it was last in possession of the father of the petitioner, hence the litigation will continue. So they have said, no, you can apply for a duplicate.
That's fine, apply.
But Your Honor, for the application of a duplicate patta book
Tell
also,
that, no, tell that it is.
I have mentioned that in the settlement memo that perpetually,
Now the whole issue is only with regard to that jewelry.
yes, the alleged jewelry, which they, Your Honor, it is,
Whatever it is, alleged or.
yes,
whatever.
Your Honor, yes.
That's the only thing.
That's the only thing. And from my end, Your Honor, it is only,
Inform them, we'll have it in the afternoon.
I'm highly obliged, Your Honor.
Yes.
Case number 41 adjourned. 42 Mahabaleshwara, okay. 42 Narayana, yes.
Yes. Where is the counsel for the appellant? Any interim order is there? The counsel for the respondent is present. No representation for the appellant. Pose this matter for dismissal on Saturday.
Case number 41 is considered.
Hmm?
Adjourned.
What is that?
Case number 41.
Yes. Next.
Monday. Saturday.
Saturday, how many matters are there as of now?
Saturday as of now.
Only, okay. Pose this on Saturday. Next.
That is 2:30.
Oh, the 2:30, next. Part third is at 5.
Password matters are there.
Call the matter. Call.
List two.
List 2 are not mentioned. It is also at 10:30. What is that?
List two that counsel has submitted in the morning. Serial number 1, list 2, K.S. Mallikarjunaya.
Lordship, I appear for the petitioner.
Yes.
And so agreed by the order passed on IA2 by the trial court. Principal Judge, Family Court, Tumkur. I have preferred this writ petition without referring the documents produced by the respondent in the trial court. He has passed an order to pay 15,000 as a maintenance to the wife.
What is your income?
The trial court petitioner is the wife of the year petitioner. Both are husband and
What
wife.
is your income? What is your income? You are the husband.
I kindly come to the orders passed. I have produced the documents also.
No, you can tell the court what is the income of the husband.
Aship may operative portion of the order kindly see this.
Income.
Annexure A.
Okay, income kit there.
I have seen that. I've seen the order. 15,000 is granted.
Yes, he has passed up
What
50.
is your income? I am asking.
I have produced the document, so
Yes.
many documents. We have taken loan to construct the building. The property stands in the name of wife. I have completed the construction, even pension loan. I have with memo with statement of account also produced. And all the retirement benefit 20 lakhs has been deposited in his wife's account, SB account.
Sir, income, sir. Madam is asking.
The income of the petitioner is pension, only pension 52,000.
What I'm asking, he is a retired person.
Yes, retired
What is
person.
his pension?
52,000.
52,000
Yes,
is his
madam.
pension, yes.
Out of which
From how long they are residing separately?
10, almost 70 years old now. And now he is paying,
Divorce is obtained.
Lordship, no, she has not applied. For pregnancy, she went to daughter's house, second daughter's house, 3 months back. Up to that, they are happily living, both husband and wife happily living, and he is taking utmost care of the wife. At the instigation of the second daughter, she has filed this petition and asking partition of the property immediately. And I have produced several documents. Statement of account, I am paying every month 50,000 to loan amount. Out of 50,000, almost 48,000 I am
What
paying.
is the income you're deriving out of that building you constructed?
She is not allowed, he stand in the name of the wife. She is not allow him to let out the
That
premises.
is also used by her.
He is, somebody is coming, she is very old now. Wife and daughter are not allowing him to let out the premises.
Please come. Agreed with the orders passed and
And there is a judgment of this honorable court, unless and until
49 of 2024 dated 25th July 2024. Whereby the court had granted maintenance of an amount of rupees 15,000. The husband is before this court and counsel appearing for the husband submits that now the husband is aged 70 years. He is getting a pension of 50,000. He has constructed a house by taking the loan in the name of the wife, and also his retirement benefits are deposited in the account, in the wife's account. It is submitted that now the house is the wife is the daughter, the house is also in the control of the wife, and she is managing the same. He submits that out of the pension amount of 52,000, he is paying 50,000 monthly towards the loan account. Towards the loan, it is submitted that the trial court, without considering all these aspects, had granted the maintenance of an amount of 15,000, which the petitioner is not in a position to pay. Considering the submission of the learned counsel for the petitioner, there shall be stay of all further proceedings pursuant to the order dated 25th July 2024 and criminal miscellaneous number 49 of 2024 till the next date of hearing. The petition is permitted to take out notice on the counsel appearing for the respondent before the trial court and file a memo to that effect by 14th of October. If the memo is filed, then post this matter on 21st of October.
Much.
Hand summons, wherever notice I say hand summons.
Yes, I will take hand summons also.
List is happening so fast. List. At 12:59, so what about their Passover is there, no? You're ready with your, yes, Passover, that matter you call, no? Passover matter.
Past our matters? Now this is number, huh? 5. Number 5.
Yes.
This writ petition is filed challenging the dismissal order filed under section 311 of CRPC, my lords, to cross-examine the respondent. The very reason is the respondent files her assets and liabilities on 19/3/2024.
That order, what is that recall order is there? 19/3/2024. What is the date?
The recall order is 19/12/2022.
Where is that order?
Page 272. After RPFC, my lords.
272.
Yes.
What it says, the PW1?
Has cross-examined the PW1, the respondent.
I'm not able to understand. Read it. 21/12/2022 order.
PW1 and counsel for respondent. For further cross of PW1 by 21/12/2022.
You're reading where? 19/12.
Well,
Yes.
yes, yes.
PW1 and counsel
For respondent.
absent. Absent, I think.
Yes, my lords.
Respondent.
Counsel and for further cross of PW1 by 21/12/2022.
Further PW1. So why do you set aside this order? PW1 and counsel absent. Respondent, counsel.
Respondent is husband in this case,
Respondent.
case, my lords.
Further cross-examination of who? PW1.
Yes, my lords.
So your
By 5.
cross-examination is not closed.
No, it was closed, my lords, in the
No,
on the next date, on the next date,
But
21/12,
you're asking the order of 19/12/2022 to be set aside.
to recall the order, my lord.
On that one, but the recall order should be 21/12/2022.
Yes, my lords, by oversight, it has been mentioned as 21.
So ultimately what the court did, please come to the order.
The impugned order, page 229. Page 235 is the reasoning. May I
Who is before this court, wife or husband?
husband, my lords. May I?
Petitioner has filed a statement of assets and liabilities. On verification, it came to light that though the petitioner had stated that she had SP account,
In the assets and liabilities, the wife only mentions one bank account and suppresses the another bank account, which is Canara Bank, my lords. And while filing assets and liabilities also, she does not produce a bank 3 years of bank statement, my lords. Hence, the petitioner husband files an application under section 91, summoning the banks to produce 3 years of bank statement, my lords. The bank statements have been produced before the court, my lords.
come to para number 7.
The petitioner filed this petition against the respondent under section 125 of CRPC seeking monthly maintenance. After contest by the respondent, this court dismissed the petition as per the judgment dated 19/8/2017. Being aggrieved by the said judgment, the petitioner has preferred RPFC number 170/2017 before the Honorable High Court of Karnataka, Bengaluru, and the same was allowed on 28/7/2022 by setting aside the order dated 19/8/2017 passed in the case and remanded the matter for adjudication on merits after affording the opportunity to both the sides. After remand, the respondent further cross-examined PW1 and also led further evidence and got marked some documents. When the case was posted for arguments on the main petition, the respondent has filed several interim applications and the same was disposed of. Now the case is set for arguments on the main petition. At this stage, the respondent has come up with this application seeking permission for cross-examination of PW1. It is pertinent to note that the respondent at the first instance and also after remand of the matter from the Honorable High Court of Karnataka cross-examined PW1 at length. No doubt it is true that the respondent had filed application IA number 16 and 17 for summoning of bank statements of the petitioner from the manager Canara Bank, Ashok Nagara branch, Tumkuran, manager State Bank.
So now, according to you, she has committed the perjury.
Yes,
And
my
for
lord.
that, a separate criminal miscellaneous number, so and so is registered.
Yes.
In that, again, the inquiry will be conducted by
Yes.
the court. There you can have all
Yes,
that.
but now, my lords, the application has been rejected.
No. Court has observed, come to page number 238. Separate criminal miscellaneous number 101 of 2024 is registered for adjudication of the said matter, and the said criminal miscellaneous is pending for consideration.
But now, my lords, now it has been rejected. So hence, there is no guarantee that page
When was it rejected?
on Friday, on 3/9/2024, my lords.
When is this order passed?
This was, the order was passed on 9/7/2024.
So after this application is rejected, you have filed this one.
Yes, my lords.
Take notice, we'll see.
My lords, but now it has posted for judgment, my lords, on the 13th.
Matter is posted for judgment, what we can do?
Because the trial court.
The fag and what are you doing till the matter is posted?
It was
for
actually
judgment?
deferred, my lords, until the disposal of the.
You haven't
rejection.
even questioned it immediately after the order is passed. You wait till now for 2 months.
My lords, it was actually deferred in this case, my lord. The proceedings were deferred until the disposal of the criminal miscellaneous 101, which is the perjury. Hence, we were waiting till the disposal of the.
Then when was it posted for judgment?
Three of this month, my lords.
The day that criminal miscellaneous is dismissed, on the same day it is posted for judgment.
No, my lords, it was, the case was actually deferred and it was.
I understand that. Criminal miscellaneous, according to you, was dismissed on 3/9 with regard to the perjury proceedings.
Yes, ma'am.
So when is this? No, till such time this.
No, it
matter
was
is
actually
deferred.
posted for arguments on 13 this month, my lords, and we were not given the opportunity to address the arguments also. Now it has been posted for judgment, my lords.
Where are the docket proceedings? To show all that.
I have applied for the certified copy, my lords, but till date we have not obtained any certified copies, and we don't know.
The miscellaneous 311 of 2013.
Yes, my lords, but
And it will go to the High Court. You have got enough opportunity. You don't do what you're supposed to do at an earliest point of time. Now, when the matter is reserved for judgment, we cannot, by how this court will interfere.
But it is very much necessary to obtain the truth from
If it is very much necessary, you should come before the court at an appropriate.
But
time.
it was actually deferred.
Can't help it. The court can't pass any orders. Notice to the respondents. petition is permitted to take out notice on the counsel appearing for the respondent.
The judgment is on,
before the Trial court, no, we.
Lordship, I can make a 29th, it is posted for judgment, my lords. Before that, I,
Before that we'll press-
no, actually, the thing is,
Before
they have,
that we will post this matter.
my lords, what happened? They have not given certified because they have given only 2 days of time, my lord.
Your understanding, I'm
Yes,
saying, we'll post this matter before that.
29th.
The, land counsel, the petition is permitted to take out notice. 29th is, Sunday.
Sorry, 27th. 27th.
The land counsel, the petition is permitted to take out notice on the counsel appearing before the trial court and file a memo to that effect by 25th of September. If it is filed, post this matter on 26th of September. This is a row.
Why? When he
Lots.
List number 3, serial number 20 is a division bench matter.
1 minute. Serial number?
20.
Yes.
MFA 3202.
21.
Non-compliance of office objections for third time. When will you complain? Let me complain, we'll
Yeah,
ask him
we have filed the submissions. The 12% that is additional market value, the dates are available in the record itself. That is preliminary notification and plus the award. The preliminary notification was passed on 24/7/2006 and award is on 24/7. 1 year, 4 months, the interest we have calculated. That is available on record.
No, what I'm saying is, now it's coming up for the complaints of office objection.
So what I have done is,
And according to you, it has to be before the division bench. We'll direct the matter to be listed before the division bench. And when will you comply with the office objection?
kindly see paragraph 20 minutes.
No, for that, we have to take the file. So please wait. Yes.
My lords. My lords, one submission before. My lords, one submission. Morning, I'm sorry to interrupt you, ma'am. My lords, morning. My lords, I just wanted to pray for grant of liberty to file my written arguments in one matter, my lords, which is posted on 30th.
Who is your senior?
My lords, Gautam.
Ask him to come. Ask him to come. Why is he asking you to make these kind of submissions before the court when there is no matter before the court? How can you say out of the way that I will file something and morning also one matter is going on, you ask for another one? Is this his instructions you are submitting or you're in your own?
No, my lords, on the.
Ask him to come. Ask Gautam to come. Ask him. Yes, next.
List number 3, 230 matters, serial number 1, Raghunath MD. For appellant. Shenmukappa.
Is there online? Look at it. There is no representation on 17/9/2024-25. But yes, right, it's at 7/5/2025. There was no representation on 17/9/2024. On behalf of the appellant, this matter was directed to be listed today under the caption for dismissal. Today also, there is no representation on behalf of the appellant. The memo of retirement is filed by the advocate, which is not accepted by the court till now. And the memo of retirement do not contain any of the details that view of the matter. Appeal is dismissed for non-prosecution. Yes, next.
Serial number 2. Prashant BR.
The land acquisition appeal of 2023. The office objections are not complied with. And this matter is placed before this court on 17/9/2024 as there is no representation. And the same is posted for dismissal today. Today also there is no representation. It appears that the appellant is not interested to pursue the matter. Accordingly dismissed for non-prosecution. Next matter also.
Serial number
Same.
3. Serial number 4. Suresh MG.
Yes. This is a RPFC of 2020. Earlier, by order dated 18 September 2021, in view of the peremptory order dated 33/2021, the petition was dismissed for non-prosecution. Thereafter, an application is filed to recall the order dated 8/9/2021. Then this court had allowed that application and the order was recalled. and thereafter a week's time is granted to comply with the office objections. In spite, and the office objections were not complied with. On 13/6/2024, this court has passed an order stating that directed the matter to be listed after complaints of office objections. Thereafter also, no, the office objections are not complied with. And when the matter is listed before the court on 17/9/2024, as there is no representation on behalf of the petitioner, this matter was posted under the caption for dismissal. On 18/9/2024, today also, there is no representation on behalf of the petitioner in a RPSC of 2020, because the objections are not complied with. No, even till today, the notice is not served. Already the matter was dismissed for non-prosecution, and later it was restored. Even after that also, the petitioner has failed to comply with the office objections in view of the same. As it appears that the petitioner is not interested to pursue the matter, the RPFC is dismissed for non-prosecution. Yes,
Till number 5, for orders matter, Ajay Shankar Rao.
yes. Yesterday also no representation.
No, no. In fact,
Yes.
my lord, your lordships may see the order of 11/11/2021.
Yes,
This honorable court had permitted me to serve the counsel representing the plaintiffs in the lower court.
that you have served.
Yes, and I filed a memo on 4/12,
Order dated
11/11/2021,
11/11/2021.
please. And I have filed a memo, my lord, in compliance.
1 minute.
Yes.
No, you are permitted to serve notice to respondent 1 to 8
Please,
before the trial court.
please,
Where is the memo?
not on 4/12.
This court by order dated 11/11/2021 had permitted the petitioner to take out notice, personal notice on the counsels representing the respondent before the trial court. That is respondent numbers 1 to 8. And also officer issued directed to issue the emergent notice also. Then counsel for the petitioner submits that as per the memo, as per the order passed by this court. Yes, sir, the notice.
4/12.
No, for them, we have already served. When did you file the memo?
Not on 4th December 2021.
4th December. What is that? To produce the acknowledgement given by the counsel for the respondent number at the time for having served the along with documents.
Yes,
It's only not for all the respondents.
the plaintiff, my lord.
Huh?
The respondents number 1 to 8, they are the plaintiffs before the trial court. I've served the counsel representing the plaintiffs before the trial.
Advocate for appellant received papers with court fee labels of other side served.
Yes,
They are all the plaintiffs, all the respondents.
they're all the respondents. Respondents number 1 to 8 are the
Are the plaintiffs.
plaintiffs before the trial court.
Yes, filed a memo before this court dated 4/12/2021. As for the same, the notice is served on the counsel appearing for the respondent plaintiffs before the court. Now, the wakalat is filed on behalf of R1. That is one of the plaintiff. Plaintiff number 1 is R1. R1. And notice to R4, R5, R6, 7, and 8 is dispensed with by order dated 11/11.
They're served. They're all served. The dispensation is only- yes.
R9 is dispensed with, and R4, R5, R6, R7, R8 are shown as already notices served on them. As looking at the memo dated 4/12/2021, and as per the orders, he has already served the notice on the counsel of the respondent. Notice to R2 to R3 is held sufficient. Pose this matter for admission. Yes, next.
Then number 6.
Date may be fixed, my lord. Request for the
Date.
date.
Post on Saturday, no matters. Less matters, Saturday.
Great.
Yes.
Cell number 6.
Please, my lord, I'm for the appellant in this case.
14
Is appointed as a,
Naresh Kumar.
as appointed as a party in person, my lord, to assist the court, my lord. There is 2 office objections, my lord. In aggravate para, the impugned order date is not mentioned. And the one more office objection is that, my lord, in respect of Haye, the annexure has to be removed. But as per this Haye, my lord, they have not mentioned any annexures in this regard, my lord. And the matter is very urgency because tomorrow is the case is posted for evidence, my lord. That's why there is an urgency, my lord.
We'll hear it tomorrow.
My
The
lord,
office
tomorrow
of-
is the evidence started, my lord. If it is evidence started, you will lose his
Nothing
right,
will
my
happen.
lord. That's why, my lord, there is
Nothing
an
will happen.
urgency.
You are there, you argue the matter tomorrow. The office objections or it is submitted that you. the
I'll
right
comply
that
here only, my lord.
as far as the date of the impugned order is concerned, then counsel for the petition is permitted to comply with the same. The other office objection is overruled.
Please,
Pose this matter tomorrow.
I'll comply this.
Give the file to her.
Please.
Yes, next.
Cell number 7.
Please,
Anand Veerananavar.
Defendant is not shown as a
My lords,
respondent
the
here.
defendant number 1, I am not claiming any relief against my lords.
But still, the cost title should contain all that. You can, if you're not if you're not claiming anything, there can be a note below saying that no relief is claimed. So he's not a proper and necessary party to this.
To that extent, my lords, I made in para number 2 amendments, I made it.
Whatever means, cost title should be there. The office objections shall be complied with within a week's time, default order,
My lords, maybe have it my day after tomorrow, my lords.
day after tomorrow,
Please, please.
day after tomorrow.
Oblige.
Yes,
Cell number 8. Cell number 8.
Copies have been served.
you're appearing.
Please,
Yes.
one indulgence if I can seek. Lords, the valuation,
Interim order is granted in this.
well, interim order is granted till today, please.
Have it on Saturday. We'll not
But
hear
it's
any
not-
matter in the orders caption.
No,
That's
for this matter, my lord,
Huh.
the matter might have to go before the honorable division bench for this reason.
valuation.
Valuation, my lord, the valuation para itself is not mentioned. So
No,
only
the
to
KPID
that extent I'll seek the indulgence.
What is that?
The KPID appeal.
Huh.
But in this, I don't think there are matters of valuation because the act under which the statutory appeal is governing, it does not say about anything about valuation. So section 16 of the KPID Act, and I had also pointed out to a circular of the High Court, pointing out it will be treated as miscellaneous.
It should be treated as an MFA.
That's all.
When
that's
it, once it's MFA and
Look,
then
this-
the valuation will always be there, whether it go to the single judge or a division
No,
bench.
it is not about, since it's a question of law, let me also just assist the court on that part, because it will decide ultimately whether all these appeals will come before the single judge or not the division bench. If the act prescribes something of that nature, definitely. Otherwise, I don't think I can, because there is nothing dependent on valuation in the statutory appeals.
No, Act says that it should be an MFA.
It's not the act what says it's an MFA, it's a circular of the registry which says we'll treat it as an MFA.
All the appeals, what's the difficulty? Either
I
before
have
single
no
judge or-
difficulty, the
Go
same
before the
argument will have to be addressed before.
Go before the
I've-
division bench.
But
Go before the division bench.
as an officer of the court, if you can assist the court, my lord.
We can, if we can have a ruling on that, that is all.
Several matters are, no, not that, my lord, it's a great privilege to appear before your lordships, my lord. But as an officer of the court, several matters are being
have that
decided before the
decided
honorable
possibly-
division bench on daily basis. And secondly, my lord, it is not the act which subscribes, my lord, whether it should be to the DB or the SB. Because when for that matter, MBC or the CPC, my lord, when it comes to MFAs or RSS, does not prescribe so.
Yes.
My
High
humble
Court rules
submission,
there.
my lords.
We'll have to go to the High Court rules. That is why I'm not, if it can require a ruling to that effect, it's only on an academic issue.
We'll
That's-
have it on Saturday.
It's not, only request, it's not Saturday. If not Saturday, it's not
You
Saturday.
have a stay in this.
Yes,
We are
but
there
it's not
before the
Saturday.
court.
It's not Saturday, Monday or Friday. Any one of these.
Friday,
Very good.
this Friday.
I'm for the Tara bench, my lord, assisting the court, my lord. Could it be, my lord, Monday, my lord?
Monday.
My lord's convenience, my lord.
Monday.
Deeply
Monday.
obliged.
And-
Deeply obliged.
No, what is your name?
Veeresh R. Budhihar, my lord.
And so it is submitted, you are already filed wakalat?
No, please, my lord,
It is
because
submitted that he has instructions to file wakalat on behalf of the respondent in the name of so and so. Pose this matter on Friday.
Saturday, please. Monday, please.
Monday.
Monday, obliged.
The protection granted must be continued till.
Interim order earlier granted is extended.
My lords, I will not be after a pound of flesh, my lord. I must state under Article 12, I'll ensure, my lords, that I'll take the orders of this honorable court before I proceed, my lords. Obliged, deeply obliged.
Right, even.
Court, court.
Cell number 9, Pujappa J.
I filed my affidavit for assets and liability.
Why is it
It was ordered in the
for
last day.
orders? I'm not able to understand. Why these matters are coming up on this orders caption? Assets and liabilities filed with advocates for interest statement of objection. You should come for a regular hearing. Pose this matter on Saturday.
Kindly have it next week.
Saturday.
Kindly have it next week.
Next week.
Why not convenient to you?
Saturday is not.
You have an interim order in this?
No.
No interim order? Then we'll let it go beyond vacation.
Yes, ma'am.
Pose this matter with the request of non-constitutional petition on 15th of October. Yes, next.
Cell number 10,
Post after service of notice.
Also appearing for petitions, no?
You are appearing?
Right.
What is?
Respondent is suffering from viral fever. We will file the affidavit on Monday.
I am appearing for the petition.
I'm for petitioner, your lord. Serial number 10.
11 it is.
11,
I'm appearing for the
Yeah.
petitioner in seal number 11.
Yes,
This is
ma'am.
the case where
Serial number 10, I think this is called.
11 was called. I apologize.
I'm appearing.
Wait, no, you appear in 10
11.
or 11.
11. 10.
Await service of notice. Post after service. Yes.
11, Arun
11.
Govind Raj.
I'll file the affidavit on Monday. She's suffering viral fever.
This is the case where the custody of the daughter was to be handed over for 1 month.
We will give the school details on Monday.
Details were to be furnished if, in
Affidavit.
the alternative, this court deems it appropriate that a direction just be issued to the respondent to include my name in the
Let that be.
court record, in the
Do that,
school
do that
records.
and come back on Monday, no further adjournment.
Monday.
At the request of learned counsel, the respondent poses and why is it coming in order, sir?
They have not complied with the objections on
After
statement.
signature, we have to sign on the objections.
What is this 19/8/2024?
Each
What is
On
this
statement of-
19/8/2024?
They have filed statement of objections on 19th of August. Each and every page is to be
Page we have
signed
not
by the
signed.
council.
Not put our
We have
signature.
not-
We will do.
Signed by the council, give it to him.
No, I'm
Why
a
don't
proxy. I'm a proxy. Kavita is Monday.
office objections
Will
shall
come.
be complied with by Monday, pose this matter on Monday.
Grateful, your ladyship. In the meanwhile, this court had made an interim arrangement of video calls for half an hour. If that may continue.
The earlier arrangement shall continue,
Grateful.
the next date of hearing.
Much obliged.
Cell number 12, Jagdish KG.
The petition, my lord. I've completed the office objection, my lord. The copy has been served, posted for the, given a PF, I've paid a PF for the respondent, my lord, but not to the trial court advocate, my lord.
Furnishing of PF professor, so not taking. What was the order by this court?
To furnish a copy, to pay the PF for the respondent, also to the respondent who is advocate who is appearing for the respondent in the trial court, my lord.
Then why did you not do it?
That I couldn't give it
And
address.
counsel for the petition is permitted to take notice on the counsel appearing before the trial court shall file. a
Petitioner
memo
is
to the
present, my
effect-
lord. Petition is present before the court, my lord.
So
No, I was just making a mention.
what is to be done if the present petition is present before the court?
Yes,
Take out as per the order, though this court has ordered the petition to take out summons, hand summons on the counsel appearing with respondent. It is submitted that they couldn't take the same, pose this matter on 14th of October by the time the memo shall be filed.
Cell number 13,
Much obliged.
10 days time, my lord, madam, lord.
Finally, a week's time is
Yes.
granted for complying with the office objections. Why are we not taking, give that, when is the order, why is this happening?
The copy served on the respondent, my lord, by way of postal service and
I
also the
said,
courier.
it is by way of a hand summons.
Please.
And
Then
from
this-
how long this is coming?
So last time,
When was the order?
yeah. August, my lord.
And then now by how many times it will come?
At the last chance, my lord. Last time. 10 days and last time.
This is on 16/7/2024 is the order.
Please, my lord.
How many times it will come before the
The last
court?
chance my lord recording.
Huh?
Only copy served on the
Why did, you
respondent.
should do something what the court says, not what you want to do. What did the court ask you to do?
The true fact, my lord, because it is only the copy sent to the party
We will-
respondent.
I'll post this matter next week. By that,
Please.
I'll post it on 30th.
Please.
If the needful is not done, we'll dismiss it on that ground. This court on 16/7/2024 had directed the petitioner to take out notice on the counsel for the respondent appearing before the court below. Even till now, the same has not been complied with. Post this matter finally on 30th. If the memo is not filed to that effect, the writ petition stands dismissed without further reference to the court. Yes, next.
14, Mohan Kumar, non-taking.
Serve the notice, your lordship.
When you appear?
Respondent.
Oh, you go. Already the office object, already there, no. Why they, when the respondent is appearing before the court, what is the significance of this? That is, it's waste of time. Respondent is appearing. What is the purpose of all this that they should appear? They have appeared. As the counsel is appearing,
Your lordship, kindly
the
extend,
post this matter, counsel for the respondent is appearing, post this matter for preliminary hearing.
kindly extend the interim order.
Interim order earlier granted is extended in that.
Kindly have them
15,
next week.
Yes,
Oblige. 15?
yes.
Madam, date.
15,
Madam, date.
Chandranath Ariga, K.
No representation for dismissal tomorrow. Yes.
Serial number 16,
In this case, my lord, PF is given to the
Petition of-
respondent number 1, my lord. 2 to 4 are minors, my lord. Dispensation memo is filed, my lord.
No, this will order, a memo is filed seeking dispensation of notice to R2 to R4 at the risk of appellant, the same is dispensed with. Then what about, how many are the other respondents?
Other respondent number 1, wife, my lord.
You have paid the PF.
Yes, my lord.
Only there was a direction to take out notice.
What happened, my lord, in the trial court, my lord, there are 2 advocates, my lord. That's
The
why it was
issue notice to the respondent number 1. Post after service of notice. Next 17.
number 17,
Wait, my lord.
serial number 17.
I appear for the petitioner, my lord. My humble submission before this honorable court. This honorable court permitted me to take out the hand summon and serve it on the counsel for the respondent in the trial court. So therefore, I have done that and I
Where is the
filed.
memo?
So I filed a memo along with the acknowledgement.
What is the name of the advocate?
Jagdish Acharya, who has
As per the
received.
order passed with this court. When counsel submits that he has already served the notice on the counsel appearing before the trial court and filed a memo to that effect. Where will you get the name? What is his name?
The name of the respondent. I would like to assist this court. I would like to assist this court by referring to the page number. Page number 91. So his name is mentioned in the Wakalatnama, which is Jagdishwar Acharya.
In the name of Jagdishwar Acharya as a counsel for respondent. Yes, vote this matter next week.
My lord, my respectful submission, if you could please accommodate a date after 28th of this month.
30th,
Much obliged.
yes.
For non-compliance, serial number 18. Prashant BR,
18, 19
up to 20.
till 20, no representation for dismissal tomorrow.
Serial number 21. Siddhi
Yes.
Sudhana.
The
Why
obvious
this
say,
advocate is not practicing?
Pardon?
Mr. Prashant BR?
there are 3 more Prashants.
No, like, there are several matters are coming before the court. In none of the matters he is appearing.
Corporation advocate, huh?
No, Prashant BR.
No, there are number of Prashant, is it a corporation matter?
No, it's a land acquisition matters. It's been at least 20, 30 matters or dismissed for default till now.
Just a minute.
Uh,
The office objection is
mm,
that I have not 21, huh?
yes.
Office objection is that I have furnished the documents
Let's
for,
1 minute.
I have,
The
second set
following
is filed on
of
10th.
document to be furnished to verify the 12% additional market value.
Yes, kindly see the paragraph 3 of the judgment, in page 19. The judge, honorable judge has himself recorded the dates. Para 3, page 19.
Mm.
My lord will find it on the fifth line. The preliminary notification was issued in the Gazette on 20th/7/2006, and final notification on 20th/5/2000.
No, the
So-
decree will disclose all that.
Yes,
Where is the decree?
decree is not disclosing that. That is the reason. Decree is, my lord will find it at page 48 and 47. It simply says, it is further ordered, page 3 of the decree, award that the claimant is entitled to additional market value at 12% per annum under section 23 1A of the Land Acquisition Act on date of 4/1 notification till date of award.
No, you find it 48 bottom. Page number 48.
That is 30% solatium and 59% for 1 year interest at first 1 year and 15% for later year. 12% additional market value, yeah, it is from date of the preliminary notification till the date of award. Those the dates are available in page 3 of the para 3 of judgment.
No, ultimately it is a decree that has to be executed. The decree has to contain all that. That can't be collected from the judgment.
The decree is the office
Has
of the
to,
trial court.
because now even if you have to file an execution, then that has to be looked at from
So
this.
they have filed the execution by making their own calculation and the execution is pending now. Now this was the remanded matter by the division bench. Now division bench directed that they consider all the documents and pass it. So I am only confining kindly see my paragraph 20.
No, I think that the division bench decide about this also.
No, kindly see, my valuation is this. I am not questioning the entire award. I am only questioning the award to the excess of 2 crore.
According to you, what is the amount now? The appeal of the valuation of the appeal?
I'm not challenging the entire award. I'm only confining my challenge to the award which is in excess of 3 crore 15 lakhs.
How much?
3 crore 15 lakhs 43,053.
3 crores 15
3
lakhs?
crores 15 lakhs 43,053. Accordingly, I paid the court fee, whatever may be award is.
The the appeal is valued at 3 crores 15 lakhs 43,000.
53. Kindly go to page 16, madam.
53. And the registry is directed to place the same before the division bench. Yes.
A date may be given, madam.
The post on it is submitted that there is urgency in the matter. Post this matter on 26th.
In meantime, I am also complying the office
In
objective.
the meantime, the petitioner shall comply with the office, appellant shall comply with the office objects. This next.
Cell number 22, Syed Umar.
Appearing for
Sir,
appellant,
Jagadish.
days time, 4 days time.
A week's time is granted, default. Yes.
Cell number 23,
Well,
Page
Earlier,
B.
earlier officers has raised 3 objections, my lord, which are completely, my lord, complied with. Now, my lord, additional 2 objections were raised. One objection is that, my lord, I have to file translation copy. Within 2 weeks, I will file, my lord. And another one is, my lord, name of the appellant is not tallying with the, my lord, trial court.
Let's see that.
In respect of
Appellant is the plaintiff.
no, my lord, is a defendant, my lord.
Huh?
They are appellant is a defendant before the trial court.
So let's
They
see
are
that.
wrongly stated as my lord, Anjani Appa. His name is Anjan Appa. They are wrongly mentioned as Anjani
So
Appa.
now you can't afford to, you should say something, but it has to be as it is. The cost title you can't change and you can't, office objections to be complied with, 2 weeks time is granted to comply with the office objection.
Cell number 24.
By doing all this, you're making the registry, their life very complicated. With all this, they have to
No,
work like a court.
Before trial court only, my lord, in my cast title.
What will happen is, what they have to basically look at is, what is the cost title there, cost title here. What else you want to say, you can say after that, but the cost title has to be the same one. Schedule also, it has to be the same. Those are the basic things they will do. Yes.
Cell number 24. Prakash
Well-
BN.
For the appellant, my lords, a week's
Yes.
time will be granted, my lords, to comply with the office objection. Week's time, my lords, to comply with the
Week's
office.
time. Yes, next.
Please.
Cell number 25.
No representation.
Raju.
Post for dismissal tomorrow. Next 26.
Cell number 26.
Around a week's time will be granted. A week's time is granted for complying with office objections, same default. Obligement. Yeah, call the passwords.
Passover matters. List one, cell number 10. Suyo Kerala.
For the petition.
For the petitioner. Yes, what are your instructions?
The DD is ready, my lords.
Ready?
Ready, my lords.
To him.
By tomorrow, my lords, I will deposit before the court. My lords, he resides in Mangalore. Yes, send me the picture of the DD. Drawing the name of Registrar General. High
Tomorrow
Court.
we'll have.
Please.
You will get it tomorrow.
Tomorrow I will get it.
Give it to him.
Please.
You can hand over it to him, we'll record it.
Please. I have already drawn in the name of Registrar General High Court of Karnataka.
Huh?
I have drawn in the name of Registrar General High Court of Karnataka.
Why all that
Since
procedure?
the direction was, my lords, to deposit before the court.
Yes, let it be, court will grant at the request of learned counsel, the petition. Instead of tomorrow, we'll have it day after tomorrow.
Day after, please.
Day after.
Interim order subsisting.
Interim order earlier granted is extended
Great.
Great.
Cell
till the next
number-
date of hearing.
Please.
Yes.
Cell number 16. Sidmalappa PM.
Why is it, matter came up in the morning. This court has directed the matter. Morning adjournment was sought. And this court has asked the junior counsel appearing, asked the senior counsel to appear before the court and argue the matter. In the afternoon, there is no representation. Post this matter for dismissal on Saturday. Yes.
Cell number 40.
Your Honor, I'm the respondent
Number
party.
40.
in person.
Samantha Pujal.
Yes. This is your proposal.
Yes, ma'am.
Yes, I have just now received.
Pass it on, you have given him a copy of
Yes.
it? You have a copy?
I have just received it 2 minutes
Oh,
back here.
just look at it.
Yes, Your Honor.
First, read the first one. 2A, you read it?
Madam, please you read it.
Read
decree
2A.
A decree may be passed dissolving the marriage solemnized on so-and-so registered in the office of so-and-so between the petitioner and respondent by granting a decree of divorce, and the same may be noted in the sub-registrar's office.
Next.
The petitioner submits that the respondent shall pay the entire maintenance amount as has been awarded by the first additional family court. On 12/1/2024, the award has been passed. Up to date, till the passing of the decree, only that much portion we have asked, my lord, till the passing of the decree.
What will be the amount?
So according to my calculation.
How much is granted?
It's 25,000, my lord, only to
Per-
the daughter.
25,000 is granted.
25,000 from 12.
That order, that he has not challenged that order?
I have, Your Honor, raised an objection there.
Oh, that name and all, please don't again
But
start.
Your
that.
Honor, it is the execution she is talking about, which is being challenged here in this court, Your Honor.
Not
And
execution, order of maintenance is not challenged.
Separately, it's
I-
not.
5,000.
No, my lord.
You have not filed any appeal against that.
no, Your Honor, I have contested the same before in this matter itself, Your Honor. because
Understand. You have.
I have
questioned
not filed
something-
anything separately. No, Your
So you have not questioned that order of granting maintenance of 25,000. That order has become final. All the
No.
names are not,
Your Honor, I have filed a review petition before the same court, but
Court cannot, there can't be a review for that. You have to come before the other court, for the appellate court, not the.
Your Honor, there might have been a erroneous order because my income itself is 25,000, Your Honor, and it is
You have to
granted as
come before the High
25,000.
Court. You have to come before the High Court.
But Your Honor, the section 114 of CPC gives me a chance to file if there is a erroneous order. Your Honor, if my income is 20,000.
When did you file a review?
Your Honor, the exact date,
Was it entertained?
yes, Your Honor, it was accepted and they had given on a second thought, on an afterthought, they filed this writ petition the very next day, Your Honor, on which it was ordered.
1 minute. Now, at this 25,000, how much it would be?
My income is,
It's only paid
I'm sorry.
25,000 till date.
yes, Your Honor, yes, Your
It will come around 30.
It is like application is filed on 3/8/2021. That is 3 years.
Order was from 3
3 years, almost 3 years.
Yes, ma'am.
Because 3/8/2021, not 3 years,
Date
it's
of-
2.5 years.
Yes, ma'am. 25,000 per. year.
22, 23, yes, 2.5 years.
Yes, ma'am.
2.5 means 24 plus 12, 36 months. It comes to 9 lakhs.
Comes around, yes, my lord.
It comes around 9 lakhs.
Yes,
That
Your
is
Honor,
one.
I have a humble submission, Your Honor, in this.
Please understand, court is not passing any order. I'm only understanding
Yes,
their settlement. I'll ask you,
yes,
please
yes.
wait.
Yes.
Only till the date when a decree is passed in this court, my lord.
Then
We are
next,
not asking for.
next, two.
Two is this petitioner would accept whatever maintenance or alimony this court may determine for both wife and the daughter. We are not making any specific claims here.
Hmm.
Now, the problem is the amount should be deposited in the name as given in the clause because.
So it
again,
has to
he
be
will-
by way of a money transfer.
Or DD.
Yes,
Because
yes.
I don't want any games to be played.
Yes, yes. Next.
Next is the petitioner shall be the sole guardian and custodian of the minor daughter. And respondent should not interfere in the upbringing of a daughter or her education.
Yes, next.
The respondent shall withdraw all the cases filed anywhere in Karnataka or India because he has filed some cases in Maharashtra also.
Yes,
And he has to withdraw it unconditionally and report it before the decree of divorce is granted, and he should not initiate any further civil, criminal or any proceedings of any other nature.
yes,
And the respondent shall withdraw the notices issued to the advocates unconditionally and issue an apology for it, my lord.
yes, next.
The respondent shall return all the income tax returns in originals if any.
Why do you
filed-
incorporate this clause? It's
Because-
all done.
Ah.
Why do you unnecessarily, like in their affairs, why do you want to come in?
No, in the name of respondent, in the name of
If it is
petitioner.
paid in the name of the petitioner,
Petitioner, my lord.
let
Only
that be recorded with me.
because what has happened is after the marriage, all her PAN card and other documents were made by the respondent herein. So if they have done.
No. I'm talking about E.
I'll clarify this one. Till marriage, she was not an SSC. After marriage, she got declared an SSC.
I am on E.
The
Notices.
response shall return.
The respondent shall withdraw.
Yeah, they are in his
The
custody.
notice is issued to the advocates unconditionally.
If any time.
I don't think it is required. Next.
That time I'll make it. I'll correct it.
Yes,
No problem.
next. Next, 5F is the respondent shall return all the income tax
Income tax
returns in
returns
originals,
filed.
if any, filed in the name of Nikita, and also Nikita shall not be liable to pay any income tax dues, GST or such other dues to the state government.
Post-marriage,
Incur so and so. Next, the respondent undertakes that the
petitioner
petitioner
is authorized to get the birth certificate and such other documents corrected by giving the name as decided by the mother.
that is Tisha Jain, daughter of Ashish Agarwal. The respondent
The
demands that
demands
his
that the
father's original.
now he is making a demand that one patta book for Nagari Road and some other properties have been given to us, my lord. I have confirmed with my clients, we are not in custody or possession of any of the documents, my lord.
No, what will happen is if it is not in your custody, that we will record it, then you'll have an option to file, to ask for a original document from the next.
It may be a part of the decree that if the name of the petitioner is entered into with respect to the shop which he is claiming that the name has been returned, then he is free to get it transferred. We have
Next.
no problem with it. The petitioner has no objection to change the residential address, Mumbai address, which is mentioned on her Aadhaar card and PAN card. We don't have any objection. for it.
Next.
Petitioner is ready to close the current account number so and so, which is in Mumbai.
The passbook and checkbook and other documents are in his custody. So if he returns it to us, we'll close the account,
Yes.
my lord.
Next.
Now the savings account, which is linked with the bank locker, my lord,
Hmm.
which is in IOB sector,
Hmm.
and the PPF account, which is in Mumbai, my lord. It is also not with us.
Hmm.
So now we want to get, if we want to close the locker also, we'll need the key and other things. If he hands it over to us, we'll go there, inspect. Before that, he should not go there unilaterally and open the locker or other things.
Next.
The same thing, my lord. He should return the locker key to the petitioner, which was last.
Then where are they asking about the jewels you're saying?
Your Honor, there is a memo which I have, Your Honor, as I said, on 16th, I was traveling. During my travel, I have received the email from them, which I have put it on record, Your Honor. There in point number, in my memo, they have made certain changes where they have claimed in paragraph number, it is on.
No,
No, my
no,
lord,
this is the.
I want
please-
to-
Yes, Your Honor,
This is the final memo.
Yes, Your Honor.
Everything appears to
Yes.
be reasonable.
Yes, Your
All the requests that
Yes,
are
Your
made. So what is your, no, please come out with whatever they're asking for, which are not acceptable to you in this.
Your Honor, I have also filed my individual memo,
No,
but
that-
first coming to whatever objections I
It's
have,
acceptable to you
Yes,
or
sir.
whatever, what you
it is
want to solve.
majorly acceptable to me. There are only 2 or 3 points which
Tell
are
the- tell the court.
slight amendment
Yes.
needs to be made, Your Honor. I am okay by 2A. 2B1, Your Honor, in this.
1 minute. 2A, you're okay.
Yes, Your Honor, I am
2B?
okay with 2A. Your Honor, in 2B1, Your Honor, exact dates, I'm not carrying the family court records, Your Honor. There were 2 hearings which were conducted after my review application under section 114 of CPC, Your Honor. It was on that day, the learned counsel for the
No, for example.
petitioner had.
no, It is not 20, let's say, it's not 25,000. You filed a review is pending. You cannot pay 25,000. But you have to pay something to your daughter per month,
Yes, Your
per month. How
yes.
much you will pay?
Your Honor, I have already proposed my income is 20,000, which is not objected, and I filed my 15 years of income tax records.
10,
So-
it's 10,000.
So if 30% of that is calculated, I am 6,000. I have already proposed in my proposal, Your Honor, 30% of my income, which present in the
How much it comes to?
Your Honor, it is 6,000 per month, 72,000 per year.
How much?
It is 70,000, 72,000 per year, Your Honor. And whatever I have calculated in,
He says, no, he's ready. Earlier he said how much?
Your Honor,
How many lakhs you were ready to pay earlier?
5 lakhs, Your Honor.
5 lakhs he said earlier. No, he says that he will pay 13 lakhs.
Ma'am, my lord, we have.
I have
for this
considered,
petition, we have-
Your Honor.
We have actually
What is
have
that?
let go of jewelry, we have let go of so
Those
many
of it
things.
was Jewelry are left.
We have let go
They are not
everything.
asking it back.
Now, at least the maintenance amount should be a little fair, my lord. That's what we implore, my lord. We'll abide by whatever direction this court.
Your Honor, in this context, my submission
They have
is,
not, they have, it's on so many, whatever that day, the discussion in the chamber and all. No, they have come, they have moved, when they have come up, they're more flexible. From
Yes.
this memo, that's what the court understand.
Yes.
So now it is a full and final settlement, even with regard to the child. Now that issue of jewelry is also not there.
Yes, Your
So now 2 things. One is alimony issue is one thing that you will be paying to the wife. Paying to the wife. You want a divorce, you want.
Yes, Your
You have to give alimony to her.
yes, but in the mediation itself, she had said she is a earning professional, Your Honor. She had said that
First of all,
she doesn't need
whatever
a,
discussions were conducted in mediation should not be brought before
Yes.
any court.
We are like,
I'm,
you just.
I
submit from
apologize.
What has happened from the,
yes.
on
I'm-
the
I
discussion that day in the
apologize.
chamber.
Yes,
So now, I think with all this, you can put an end to everything. Only now it is from your side with regard to the alimony, that is one aspect. The maintenance part, what will you do? This to the daughter.
Your Honor, I
What-
have,
What, no, not
Yes.
6,000.
yes, no.
Come up with a reasonable figure.
Your Honor, it's already, Your Honor, this 13 lakhs also I would.
The life, you please understand one thing, mother has to take care of the child. Why are you not understanding that? And if the girl is with you, you have to spend her school fees and all forever.
Yes, Your Honor. But I would get that opportunity to be a father to my child, Your Honor,
The court
that
is not asking you to pay or to give everything or whatever you have to spend. No, some reasonable amount towards your responsibility.
Your Honor, I have been very reasonable.
Emails that we are receiving, it's from some autosport at underscore.
That is my personal email, Your Honor, and I've been using that email from
So
2007.
Miller, which is also, it's not in dispute that he doesn't have any income.
It's from 2008.
Can you just leave it?
Yes,
Yes.
Your Honor. So, Your Honor, I am also ready to
Settle
comply with the
that
court
maintenance
direction, Your
to the
Honor.
child. What do you say?
Your Honor, I have also proposed that if the 13 lakh rupees is as it is, if it is put in the FD in a nationalized bank, 9,100 would be the interest what she would be getting per month, Your Honor. That can be easily used for uh, the monthly expenditure, Your Honor.
One consideration
And
may be given
What
to
will be
stay
the,
in
what will be
Bangalore.
the school fees of the girl in for a year?
Considering
Your Honor, I
Bangalore metro city and the expenses, day-to-day expenses.
Make it a round figure. Not 13.
First charge comes to 3,000 rupees.
Then we will pass an order. Then this would be a joint memo. And both of you sign, place before the court, then we'll pass an order. So now the whole issue where it stopped is on this.
The final amount. And only, Your Honor, in clause number G, I am ready
Hmm.
in the clause number G.
Hmm, hmm.
Your Honor, this, I have a apprehension that in future, maybe after 5, 7, 10 years, Your Honor, Tisha Jain is not.
No,
with-
you have nothing to do with the child.
No, Your Honor.
Permanent custody is with the mother.
But Your Honor, only the daughter of, she can write Nikita Agarwal, I have no objections, but how can,
Father will remain the same, my lord. How is he going to?
but
Creating an issue out of
So
it.
if he doesn't want his name to be taken, always.
Yes, Your Honor.
It's open to the mother.
Yes,
to have
Your
her
Honor.
name.
Yes, Your Honor.
I will put it to my.
Put it to
Yes.
her. That now all the, so in college, school and all the forms now are not
Mother's name
necessary
is-
that you have to mention the husband's name. She can be his daughter.
She's already done that, Your Honor. She has already mentioned her name as Nikita Jain and taken admission. If the suits what are pending in Maharashtra, Your Honor, are specifically on the same grounds where the bank check what I had issued in the name of Nikita Ashish Agarwal. Today she has mentioned that she has 3 accounts of Nikita Agarwal. She has, Your Honor, that is a,
Premarital accounts
Does
will
it
be.
matter?
no, that's what, Your Honor, I am ready
Her
to
father's
compromise.
name is Jain.
It's
So
the-
she is Nikita Jain.
Yes, Your
Now
Honor.
you have disputes with your wife, but your wife should always carry your name.
No, I don't want her to carry my name. That is my contention, Your Honor. She is
See,
using.
even you're apprehending that if she carries your name, again, some disputes on that.
So, because Your Honor,
That
she's,
you will lose in that.
Your Honor,
That is
at,
that's the difficulty. Now, a technical person reading law and trying to, arguing the case as a party in person, these kind of apprehensions will come. What are there? What is there in that?
I'm okay with
When
it.
she wants to get rid of
Everything, yes, Your Honor, that is
why
my
all
point.
these names?
Yes, Your Honor. In G, if she just amends that as Nikita Agarwal or Jain, whatever it is.
Let it be.
I'm
Nothing is
okay.
going to happen. This is a full and final settlement.
Yes, Your
What
Honor.
will happen to you? You can say that, long back, like I've get rid of all these relations. I have nothing to do with my daughter, nothing to do with my this thing. So they can't claim anything. Why do you anticipate unnecessarily? Don't look, that's not the way how you look at things. You're making your life more complicated with all this.
And only one concern for the daughter is in future, if there is some doubt, where is your father, what's his name? She should not face any kind of
These
difficulties.
unnecessarily make it complicated. No, so G also nothing to think about G. Then, so now please again coming back to this F and this not F, this this is B, clause number B. We will club B1 and 2. We will club B1 and 2. And one figure we will write. That's the only thing now.
So, Your Honor, as far as what I had proposed for 13 lakhs, Your Honor, I already have some debts, some arrears which need to be paid, which
But
is there on the
whatever
court
is the
record.
amount has to be transferred. That you are aware of it.
Yes, Your Honor,
Before filing a joint memo and this court passing an order basing on that, you have to comply so many things in this, right? From the locker thing, the amount has to be by way of a transfer or a DD that has to come before the court. On that day, you will hand over the DD to her. And all these things have to follow for a final settlement.
Your Honor, for the amount what I had proposed, 13 lakhs, I plead before the court that I need
How many?
I'll be able to file that in 2 parts, Your Honor. It won't be possible for me to file the complete 13 lakhs in one go, Your Honor. I'll file it in 2 parts, maybe exact 50% or around 50%.
It should be a full and final settlement. In between, like half it, nothing will pass. Once you pay the amount, we'll pass a final order. If you have a half, keep it here. When you have the full, then only you pay. When is that?
Your Honor, that can be mentioned maybe in the court order. I will duly comply with that order, Your Honor.
That's how, that's a final order can't be passed like that on a future event to be to happen. It has to happen by the time the order is passed. After that, no claims against each other.
each other.
Hmm. How much time you require?
I actually had wanted around 5 months time for the second half, but since the complete amount needs to be paid before, I was not aware of that fact,
It has
Your
to
Honor.
be
So,
because no piecemeal now. Because it's going to be, we are going to put an end to everything.
so Your Honor, do I have a option of filing whatever the amount is granted? I will take hand loans, I will do whatever, but I pray for a direction that I will deposit the amount in the court account, Your Honor. After all the things are settled, Your Honor, it is a humble prayer, Your Honor. After everything is settled, she may, from whatever name.
Don't deposit anything. Court is not asking you to deposit anything. You will only deposit provided we are going to put an end to all this.
Yes, Your Honor. Yes, Your Honor.
So keep it with you. Keep it with you.
But
Full amount, the day you hand over the DD to her, that day will be the day where the court is going to pass an order. Till such time, the court will not pass. And you will know you are not at risk at all.
But Your Honor, there is also from my end, in my proposal only, I have given in writing that I will withdraw 2 cases provided they withdraw the execution. Your Honor.
Everything will be with.
Yes, Your Honor.
Everything
I am.
will be withdrawn.
Only one execution case, we don't have.
Whatever it is.
Yes, Your Honor.
It
I am
will
ready
be.
to comply, Your Honor.
So
And I will file, I will deposit the amount in the court account whenever it is directed, Your Honor. On whichever specific date, I will deposit this.
I'm not clear in what I'm saying. I said the day you are ready with the DD.
Yes, Your Honor.
And the other things are complied with, that day an order will be passed. So you don't have to deposit it somewhere.
Okay.
You will have it.
I have just have a possession of the DD and based on that, the order will pass.
Whenever order is passed, that day you will hand over the DD to them.
And the dissolution of the marriage will
That day
happen
it will be.
post then, or it will happen?
We will record this and a formal petition will be filed before the trial court. We will record all this joint memo
Yes, Your
and
Honor.
filing of a formal petition before the trial court for dissolution. Basing on this, they will pass the order.
And Your Honor, there won't be any, then from their end, there won't be any.
They can't be. So when shall we post this matter? Whenever that matter, that day, by that time, you have seen the other clauses with regard to the, I think whatever to be complied is only with the locker one.
Yes, Your Honor, that
locker,
I can, the,
Bank passbook, checkbooks.
Bank passbook, check, whatever it is, look at it. You
Yes, sir.
please comply with all that. And then once you're ready with the money, whatever date you tell the court, that day we will post it and we will record it. And that day you will give the DD.
Yes, Your Honor. Your Honor, only one thing pertaining to the locker keys. It's been a long time. I also don't remember my documents pertaining to, so anything may be ordered that jointly it may be opened, Your Honor, because I have certain documents also.
It can be
And
open
we will
jointly.
take,
Jointly.
at this fixed time, we will also take our
Yes,
items
Your
from
Honor.
the locker.
What is that?
We'll, at our convenience, the response, because we
No
have the
problem. You can
total-
take, you can take
whenever
at
you
your
want.
convenience because it is in Mumbai.
Jointly open it.
Jointly.
Yes.
Because it's a joint locker, he may
Yes.
have his own things and
Yes,
unnecessary.
yes.
Empty the locker
And
on the
is the
same
date,
day.
we'll fix a date for that.
I have no problem, Your Honor.
Date.
Any date which is convenient to them
Because,
because they have to travel to
We'll
Mumbai.
we'll post this matter tomorrow, get instructions.
Yes, ma'am.
First of all, that's the only thing. Now, what about, what about this? The respondent shall return all the income tax returns in originals, if any, filed in the name of
Nothing is
Nikita.
filed
And
yet.
also Nikita shall not be liable to pay income tax dues. Have you, there are anything?
No, no, Your Honor.
Then he will mention it that it is not there in that.
I will
That
give
will
it right.
record. Next, the respondent undertakes the petition authorized together, that is not next.
Please, Your
the
Honor, in this,
respondent
please, Your
demands-
Honor, the mother's name be mentioned. I only have to that extent, Your Honor. She may mention Nikita Agarwal or Nikita Jain, whatever it is, Your Honor.
Change.
I beg before your honor,
Very,
please,
very,
it is,
she's not your daughter.
no, it's not about that, your honor, but Jain is not my surname. It cannot be mentioned as Agarwal. It is against my, your honor.
Directly is designed.
In
denying
my-
the paternity of the
I
child.
also
What is
have
the
a-
future of the child, my lord, your lordship, I kindly.
No, then you might comply with the
What
due
is
procedure.
There's a difficulty in the name.
Your honor, they have forgedly, they have done this, your honor. It is on record, your honor. They themselves have filed a affidavit, your honor. I have filed it before the court. There is no Aadhaar card which is existing in the name of.
Have the Aadhaar card, they will change the name like this. How can you stop her? Can you stop anybody saying that you can't have this name? Change it to the
So,
other
your
name?
honor, it is being imposed on me without my consent, your honor. Daughter of Ashish.
On you, what is imposed on you? Tell
Because
us
your
what.
honor, I don't know who is Tisha Jain. I know Anika Ashish Agarwal is my daughter. That is, I am agreeing to that and I stick to that. And
So many Ashish Jains. There are so many Ashish Jains. You are not alone the Ashish Jain in this entire world. It is like very ridiculous submissions you are making. Please, when is the date for tomorrow? Please confirm
Tomorrow I
it.
will take
And
instructions.
you also tell the court when is when you can get ready with the money. Accordingly, tomorrow we'll pass an order. You can appear online. You don't have to come physically. If you're going back to your place, appear online.
may it be kept for day after, because tomorrow by night I will reach Mumbai. I take a bus from here, your honor. So tomorrow I'll be in
Day
the
after
bus.
tomorrow.
Day after
Post
tomorrow.
this
I'll-
matter day after tomorrow. By that time, the land counsel appearing for the wife shall get instructions on what day she'll
Appear for the
on,
opening the
on,
bank.
wha- on which day is convenient for them to open the locker jointly.
Joint.
And your honor, since if
And the husband shall also the party in person shall also submit to the court when he'll be ready with the money.
And the figure of the total figure also.
And the total figure and the money, yes.
At 2:30, your lordship, I kindly figure, at 2:30, it can be taken at this.
Yes, at 2:30.
your honor, one small submission, when they come for the locker, your honor, the checkbooks and the passbooks, I will, in the bank itself, I'll hand over so that they can close or transfer the account, whatever they wish to.
Please do it.
So they may
that's why
take for
look at
2
it,
days time, your honor.
Look at it from a solution
Yes, your
oriented,
honor. I am.
not like
No.
coming up with all problems.
Nothing, your honor.
Yes.
I'm making it easier for them because when they come to Mumbai, they may take 2 days time. I'll hand over all the books, whatever steps they want to take, they can take it easily.
Yes,
Much of this.
I'm obliged, your honor.
give it to her.
I'll file it.
Yes.
Sale number 40. 230 matter, sale number 43. Chandana P. Somanna, Abhinav Ramanan.
Yes.
That matter. Just producing, my lord, the latest photograph to show how it is. And that, my lord, there's a third party who is involved. So therefore, his rights may have to be, my lord, also taken into consideration.
That is the problem of the landlord. How his rights you will protect.
Oh, my lord, there is another tenant already in this place.
Hmm.
And my lord, he's put up these boards. Now, any wall that may come above, my lord, Girias will definitely affect his rights.
But why did you do it? Why
But
did you
there was
let
a
it,
court order, my lord, I removed it. Fact that the court order was set aside, my lord, cannot hold that what I did was incorrect. My lord, I removed it, did not remove it without the court order. Court said remove it, it is in person.
And there was an agreement between you.
And-
contrary to your agreement, you have let it. Is it not?
No, my lord, I removed the wall pursuant to
As
the.
per that letter between you.
Yes, ma'am.
Just vacated the first floor, came down to the ground floor.
True, my lord.
And you said, as per that letter, you can retain that whatever his
That
board,
wall,
that sign is
that wall, my lord, I filed an application, court permitted me to remove the wall.
When was the application? When was the order? When did you let it, let the premises?
Yes, ma'am.
Lord, the IA 2 and 3 was filed on 7/12/2023.
Yes.
7/12/2023.
We had an interim order, IA1 was allowed, interim order was in subsistence. And that interim order was passed on 16/11/2023. It is not that there was no interim order, we were not protected. They file an IA number 2 and 3 for restitution, for demolition of wall and then remove the signage board. What they do is, without us removing the signage board, overnight at 3:30 in the night, they get the wall demolished. Pursuant to the wall demolishing, automatically the signage board goes. That was their conduct. And immediately we rushed, challenged the IA number 2, pay a writ petition. We got an order dismissing
It
IA
is
number
said that the removal of that board itself is not right.
2. Correct.
But
No,
then
no,
what
No,
should follow?
demolition of the wall is not right, so we've challenged it in the writ petition. The court said, this honorable court made certain observations saying that how can in our suit, when they have not filed any written counterclaim, how can in our suit without filing a counterclaim, they file this application which is in nature of mandatory injunction, come and demolish the wall. So these were the observations and findings in the by this honorable court. First, this after.
It has to be a status quo ante. If the order, the order of the trial court is find fault with by this court, saying that it should have not been done,
Yes,
then
my
it
lord.
should go back to how it was.
Yes, that application also they filed and that has got rejected, my lord.
As premature. It
Saying
was
that, my
dismissed
lord,
as
they
premature.
filed an application for restitution. That is now rejected. Because, my lord, the wall was removed in pursuance of a court order. I did not, my lord, do anything. Since there was an order of,
Court, you removed it.
yes, my lord.
Now the court, this court has find fault with that.
Yes, my
So
lord.
what
On the
should happen?
ground that there should have been trial. On the ground that there should have been trial. No, my lord, so the trial has to take place and then it has to be decided on, my lord, along with all other issues. Now, my lord, what they are going to do is, my lord, they don't have a license. Of course, it is their headache, but what they are doing in essence is,
So
my
if
lord,
there is no license, BBMP will take, what is this?
yes, my
called?
lord, what they are
BBMP will
going to do is show the orders of this court and say, I am permitted to put up. That is unfortunately what is
So that we
happening.
will clarify.
Yes, unless they,
Be clarified, unless and until there is a license, they can't put it. That is on the public law remedy they have.
yes, my lord.
So what about the other way?
Now,
No.
insofar
As far
as
as
the
the
wall is concerned, my lord, the direction is there must be an inquiry.
Hmm.
We requested the court to hold an inquiry. Court will hold an inquiry insofar as the wall is there. Only if the wall is, my lord, restored back, will he, my lord, be in a position to bring back the hoarding or signage or whatever he says, subject to
When
permission of,
when the writ petition is disposed of,
yes, my lord,
what this court wanted the trial court to do?
hold an inquiry.
Inquiry in the sense?
My lord, what happened, my lord, is since this is this part of first floor portion, I'll just give that order, my lord.
Pass on that. order.
Yes, my lord. You put it there, you have given that order.
Writ petition. Yes, we filed it.
It's filed.
It's there.
It's there.
It's part of it.
Which is the page number? This is, which is the page number?
There's another memo, my lord.
This is not this one?
No, there's just one memo with the High Court's order.
The order is dated, my lord, 28th
one I think.
February 2024.
Hmm?
28th February 2024. WP number
No, there are not.
4985 of 2024.
It's not there in this.
We have now.
Yes, Justice Krishna Kumar's order.
Yes, my lord.
What did he say?
Lord, please see para
Yes.
6, my lord.
Yes, please read.
A perusal of the rival contention of both sides put forth in IA2 will necessarily require adjudication by conducting necessary inquiry, by permitting both sides to adduce oral and documentary evidence in support of the respective claims, and not by way of summarily allowing the application without inquiry as has been done by the trial court in the impugned order, which is contrary to law and the material on record, and the same having occasioned failure of justice, warranting interference by this court in the present petition. It is relevant to state that the respondent defendants have filed the written statement merely seeking dismissal of the suit and have not put forth any counterclaim in respect of any property, much less the wall in the first floor of the scheduled property sought to be removed by them as sought for in IA number 2. Further, the relief sought for in IA number 2 have no nexus or connection with the relief sought for by the plaintiff in the suit. Under these circumstances, I am of the view that the impugned order passed by the trial court deserves to be set aside. IA2 deserves to be disposed of by directing the trial court to conduct necessary inquiry and proceed further in accordance with law.
No, by virtue of this order,
Yes, ma'am.
any order that is passed by the court permitting or that whatever that order to be set aside. Now, what will happen to this order? Ultimately, if you want to have the signage, the wall has to be constructed. Wall is already removed.
No,
Wall
on-
is already removed.
Yes, ma'am.
So whether removing of such a wall is right or wrong, this court had directed an inquiry to be conducted. That inquiry has to be conducted. So what we will do is, like, what is this IA number?
IA
This
number three, my lord.
Three, ma'am.
IA number 3, that inquiry to be conducted. We'll ask the court to expedite it. So one court argument, the entire High Court is able to hear.
Make, if I may be permitted to make a submission, not with this particular thing, we had filed a clarification IA, my lord. After that, the Honorable High Court had clarified on the next date saying this. that
IA
we
number
not-
2 is disposed of.
That
is
is
what they
being
have said.
disclosed of, saying that there need not be any, need not be any trial based on that. We have produced it in the subsequent
Page, yeah.
That's in page 3. There was a confusion with this, my lord.
What
Lord,
is that?
Whether IA number
Whether
2,
whether the court has to go into trial. and
Let's
check
see,
if-
IA
number-
number 3 is filed by the petitioner seeking clarification on the final order passed by this court. It is submitted by the counsel that in the said final order dated, there is an ambiguity as to whether.
whether IA 2 is disposed of or kept pending for the trial court as is necessary clarification to be issued in that regard. Final order dated 28/2/2024 clearly indicates IA number 2 has not been kept pending. Same has been disposed of by this court. In fact, the operative portion of the order dated 28/2/2024 indicates the impugned order so far as it relates to IA number 2 was set aside. IA 2 was kept disposed of by this court. It is therefore clarified that IA 2 filed by the respondent defendants is not kept pending. Same has been disposed of. Accordingly, IA 3/2024 is disposed of. It is needless to state that the trial court shall proceed further in the matter in accordance with law. All rival contention on all aspects of the matter are kept open. No opinion is expressed on the same.
But we had filed the application specifically.
So therefore, my lord, the only thing is,
My lord, I'll finish my comment.
yes,
No, before you proceed, let the court understand. What is IA number 2?
IA number,
IA number 2 is to remove the wall that is there in the suit schedule.
That's filed by the defendant.
Filed by the defendant. IA
So
number,
that an order is passed.
that order is passed.
Then IA number 2, writ petition is filed before this court. This court has passed an order saying that the issue would have been dealt with by the court by a proper inquiry. In that case, how can it be said that IA number 2 is disposed of?
My lord, that is the clarification IA here, my lord. That is the IA we filed for clarification. In that IA, we specifically asked.
No,
the
then
court-
what is the order? Then you have to read this clarification along with the order. The court says that I have no nexus or connection to the release sought by the plaintiff suit. Under these, I am of the view that the impugned order passed by the trial court deserves to be set aside by directing the trial court to conduct necessary inquiry and further proceedings in accordance with law. So IA number 2 is disposed of directing the court to conduct inquiry on IA number 2 only.
If I may read para 6 of the order, here the court says,
IA number 2 would necessarily require adjudication. And this court has disposed of, saying that that has to be decided by the court after a full-fledged inquiry, what is required. So IA number 2 is still pending as per the order. That's what the understanding of the court.
but that was the specific clarification we had sought before the court, because when we filed the restitution IA,
Then
the-
then what should be done by this order?
my lord, that is being mentioned, saying that there has to be a counterclaim and only after that the inquiry
Exactly.
how to have been conducted, my lord. That has to be read with the para where they mentioned that counterclaim has to be filed.
No.
My lord, that
What,
was
no,
the-
because, no, there is no counterclaim. Something they have alleged. So there should be an inquiry is the order of the first one that is filed in the writ petition. Now, the court has disposed of that IA should be dealt, IA 2 deserves to be disposed of by directing the trial court to conduct necessary inquiry and proceed further in accordance with law. That is in respect of IA number 2.
my lord, that is with regard to the wall, ma'am.
Hmm.
But our present writ petition is with regard to the signage board that we have put.
MF.
Both are interconnected.
My lord, the signage board can be put even without the wall right now, my lord. Because the space there, my lord, I just like to bring your lordship to the conduct of the party. We had filed IA number 7. IA number 7 was filed.
Hmm.
Lord, I'll just place few
Can't place without memo.
Photographs before it's court.
No, that's already part of the. File it in.
I'll file it with them and just to bring it to court.
Oh, what is it? This photograph.
Yes.
But before that, my lords, may I kindly see page 134 of the memo that we filed, the voluminous document. We've restored our signage board without the wall. We can still do it. It is not that we cannot put up the signage board abutting the wall. At page 134, these are the photographs produced, my lords. There was no wall, which is in subsistence as on that date. We've put up the signage board without the wall. So we can still continue to do that. It's not that there exists a wall and then subsequently we have to place and there has to be a necessary inquiry. That they can conduct an inquiry in the trial and in the full-blown trial, it can be whether we were right or they were right, whether BBMP did it, we don't have license, it will come out. Naturally, so we have the right to put the signage board as on the date. So our only humble request is let us permit to put the signage board and we'll continue till the disposal of all the IAs.
Anything to add?
Only permission, my lord. Our application.
Permission.
No permission, my lord. No permission to them, my lord. We had filed 2 applications, my lord, that signage should be removed and wall should be removed. Both are allowed. Now, my lord, question of, my lord, he requesting the court to, my lord, give him permission to put it back will not arise at all. There is an inquiry that is to be conducted. My lord, after the inquiry, suppose the removal is held to be.
Inquiry, what is, no, that is clarified, no inquiry.
No, inquiry, my lord.
Inquiry is a full-fledged trial. Now we are at an interim, now,
Yes, my
if
lord.
the interim order we have to look at, like even in the case he succeeds, now the suit takes 10 years, for example.
Yes.
So till such time, then what is the purpose of the relief that he is seeking in the petition?
In fact, my lord, there is already a suit for eviction. It is, my lord, we have filed a suit for eviction. They have filed return statement. My lord, raised a counter claim. We have filed our reply to that. It is now at the stage of trial before the commercial court.
But for your letter,
My lord,
but for your understanding.
true, my lord.
Nothing-
We
nothing
did
can
not
be-
suppress it, my lord. There is a letter. We have admitted it.
You have
We have not-
admitted it and you made him to vacate the first floor with an understanding that there will be a board, and once he comes to the,
My lord,
comes to the
our,
council.
my lord, we found fault not with his putting up of the board. My lord, we found fault with the aspect that, my lord, he misuses the trial court order. Says that, my lord, he is permitted to put up the signage board and then puts up the signage board. So this is what we pointed to the trial court. If he had an independent license, my lord, and then he had put it up, it was different. He shows the trial court order saying that he is permitted to put up a signage. Then he puts up a signage which, my lord, in my respectful submission is not permissible. My lord, even today, if he gets a
But
license,
BBMP, now the trial court order giving permission to him to put up the board doesn't mean that without the BBMP's permission.
that is what he has done.
No.
That is
that's
exactly what
incorrect.
he has
That's-
done.
That is the case, they will take care, BBMP will take care.
Exactly.
My lord, therefore, what needs to be clarified is, my lord, this order of either the trial court granting injunction or this honorable court, my lord, interfering with the order of the trial court does not ipso facto entitle him to put up a board.
Correct.
Otherwise, he will show.
No, it is like this. It is between a contract between you and him.
Correct.
As per, that is on one side.
Yes, my lord.
Now, if to erect that board,
Yes, my lord.
he has to have permissions which has to be followed.
Exactly. If he produces that permission, that is the end of the matter. That's all that we are saying.
He is not concerned.
Yes, my lord, court may not be
Whatever,
concerned, but
the
my
law
lord,
will
he
take
should
its
not,
own course.
he should not misuse the injunction order or any order of this court to say that he has been permitted to
No.
specifically put up. That is all that we are saying. If otherwise, my lord, he is able to, my lord, deal with the BBMP authorities, get a permission, put up, my lord. I am nobody to come in the way.
Yes.
I cannot come in the way, my lord.
We'll pass.
Ultimately, it is the BBMP which is the licensing authority, my lord, which
We'll
takes.
pass the order.
If I may be permitted to make a submission, we've already made an application on representation of BBMP, seeking clarification on the demolition.
Whatever it is,
There is
like,
no
let it
reply
be,
to
let it,
Let's
you
put
take
it
your
to
own
the-
courts, because the court cannot tell what the BBMP has to do or not to do. As far as the dispute between you are concerned, both of you, that we will pass an order.
With regard
And
to
we'll clarify that also.
with regard to the wall, the court is, which I object to it, the court says that there should be a clarification, I mean, inquiry made. With regarding the signage, as on date of the suit, by cause of action is that I was trying to fix the board back. That is when they interfered, my lord. That's.
Yes.
My lord,
The
fact
signage
that-
is removed is
No,
what
the
they
fact
say.
That my board is there on that date is immaterial because I'm trying to fix it back.
That I heard it on the other day with
There was
regard
an
to.
interim order subsequently as on date of the suit, my lord, the memo that I filed now, 16/2/2024. The order was passed on 15/2/2024. Overnight, they've thrown my signage board, my lord. This was the situation as on date of 16/2 in the morning. My lord, disposal of the writ petition, remainings of, there was a portion of the wall that was already left and the signage board was purposely left hanging towards the ground floor. We made an application before the trial court, IA number 7, asking the trial court, direct them to remove the portion of the wall that's hanging towards the ground floor. They filed a memo stating that they're ready to undertake and remove the wall.
Please circulate the written arguments on whatever you're
But
submitting.
subsequently, what they've done is,
No, you circulate the written arguments.
I'll do that.
Give them a copy of it. And
Yes,
circulate.
anything is there, my lord, we will also respond.
You can also.
Yes,
Yes.
grateful, my lord, grateful.
Okay, please. Yes, Mr. Gautam Raghunath, why are you sending your colleague with
My lord.
all those kind of undue requests?
My lord, my apologies. I did not know what transpired only after I, in fact, got
He
to
will
know
come,
from my colleagues.
morning he
This
will
was
come,
not
he'll
what I
appear
in
in.
fact meant for. My
No,
lord.
no,
My
morning he
apologies.
will come and
Yes.
appear in one matter and he will
Yes.
say, there is one matter is pending, some single matter, there I want to file, something he will tell, that's over. Afternoon he will
Yes,
come,
ma'am.
he will come and again he will tell that, what is that you are saying? Something, some matter you have posted to some other day.
My
In
lord, my
that
apologies.
matter, I want, I said, are you making all these submissions on your own or your senior is asking you to do it? He said,
Oh, that's-
I'm doing all this on instructions from my senior.
No, my apologies. In fact, I'd asked him to move a memo. In fact, that is all, my lords. My apologies. I'll ensure that this never happens. He's new to the bar. My apologies
No, no,
again.
that's why please, like,
Please, please.
a new junior, raw junior, please tell him, no. It
Please,
is
I
all
shall-
embarrassing for him also.
Yes, it's
So the court
embarrassing
asks
for
all
me as well,
that.
my lords. My apologies, please. Extremely.
Respect the submission, even number 17, in this today's case, there's a interim order, my lord.
17, if interim order is there, extended till the next date of hearing. Yeah. Heard and reserved.
My apologies. My lords. My
No, so
apologies.
it's-
Please, grateful.
ಲಿಸ್ಟ್ 3 ಅಂತ ಮೇಡಮ್ ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Red and reserved ಅದು.
ಹ್ಮ್.
ಅದು papers ಏನಾದ್ರು ಹಾಕೋದಿಲ್ಲ.
ಅದೇ ಅವ್ರು ಹಾಕ್ಲಿ ನಾವು ಅದು
ಅದೇ.
ಒಂದ್ ವಾರದಲ್ಲಿ ಹಾಕದ.
ಅದೇ. 17 ಯಾರ್ಗಾಯ್ತು? 39 ಗಿದೆ ಅಲ್ಲ?
to return arguments.
ಮೇಘಗೆ
Should have just passed the number. Now you've given a score for
ಮೇಡಮ್ 17 ಮೇಘನ್ ಹೇಳ್ತೀರಾ? ನಾನ್ ಬರೋದಿಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ.
single ಇದೆ.
But I'm not a ಇಲ್ಲ TR ರವಿಶಂಕರ್ senior counsel ಅವ್ರ ಹೆಸರು
ನೀವ್ ಹೇಳಿ ಅದನ್ನ ಆಮೇಲೆ ಎಕ್ಸ್ಟ್ರಾ ಒಂದು ಬ್ಯಾಲೆಟ್
ಇಲ್ಲ ಮೇಡಮ್ ಸಿಂಗಲ್ ಇದೆ.
ಹೇಳಕ್ಕೋರೆ ರವಿಶಂಕರ್ ಅವ್ರ ಹೆಸರು ಬೇಕಂತ ಹೌದಾ?
ಇಲ್ಲ ಮೇಡಮ್.
ಆಯ್ತಪ್ಪ. Held and reserved. ಅದಕ್ಕೆ ಸೇರ್ಸಿ ಇದು ಇವಾಗ ನೋಡಿ ಇದು ಸೇರ್ಸಿ ಇದೆಲ್ಲ ನಾಳೆ ಡೇಟ್ ಇದೆ. ಎಲ್ಲ ಇದಕ್ಕೆ ಸೇರ್ಸ್ಬೇಕು ಅದಕ್ಕೆ. ಇದು MFA 85 ಸೇರ್ಸಿ. ಇಲ್ಲ ಇಲ್ಲ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ 22 419. ಇದೊಂದು MFA 8 to 11. ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದು ನೋಡಿ 8159. ಇದಿಷ್ಟು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಇದು ಬ್ರಾಂಚ್ಗೆ ಕೊಟ್ಬಿಡಿ, ಅದು ಪುಟ್ ಅಪ್ ಆಗ್ಬೇಕು ಫರ್ದರ್ ಸ್ಟೇಜ್ಗೆ. ಎಲ್ಲ ಸ್ಕೂಟನಿ ಇದು MFA ಸ್ಕೂಟನಿ. ಒಂದ್ ನಿಮಿಷ ನೋಡ್ತೀನಿ. ಇದು MFA ಸ್ಕೂಟನಿ, ಇದು ಸ್ಕೂಟನಿ, RPFC ಸ್ಕೂಟನಿ ಏನಾಗಿದೆ ಹೌದು 450 ಇದೆ. RPFC ಸ್ಕೂಟನಿ ಇದು ಪೆಂಡಿಂಗ್, ನಾನ್ ಪೆಂಡಿಂಗ್ ಆಫ್ ಮೆಮೊ ಪೆಂಡಿಂಗ್ ಇದೆ. RPFC ಪೆಂಡಿಂಗ್ ಅದು ಕೊಡಿ. ಇದು 3 ಇದೆಲ್ಲ ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್. ಸದಾನಂದ ಅವ್ರು ಯಾರೋ ಎಕ್ಸ್ಪೈರ್ಡ್ ಆಗ್ಬಿಟ್ಟು ಊರಲ್ಲಿ ಅವರು ಸೋತು ಬೆಳಗ್ಗೆ ಫೋನ್ ಮಾಡಿದ್ರೆ ಬೆಳಗ್ಗೆ ಬಂದಿದ್ದ ಡ್ಯೂಟಿಗೆ, ಇವಾಗ ಮಧ್ಯಾಹ್ನ ಫೋನ್ ಬಂತು ಅಂತ ಯಾರೋ ಅವರ ವೈಫ್ ಅಣ್ಣ ತೋಟದ ಮಾವನ ಯಾರೋ. ಕುಟುನಿ ಬ್ರಾಂಚ್ ಇದು ಇವ್ರೆ. ಯಾಕಂತೆ ಬರ್ತಾ ಇಲ್ಲ.
ಇಷ್ಟು ಮೇಡಮ್ ಕೊಡ್ಬೇಕಾ ಇಲ್ಲಿ?
ಇಲ್ಲೇ ಅದು ಮೇಡಮ್ಗೆ ಕೊಡ್ತಾರೆ, ಅಲ್ಲಿ ಬೀರುಲಿ ಇಟ್ಬಿಡಿ, ಅವ್ರು ಕೊಡ್ಕೋತಾರೆ ಸದಾ ಬಂದು. 8159. ನೋಡ್ಕೊಂಡಿಲ್ವಾ ಇಷ್ಟು ಡೇಟ್ GMFC ಬ್ರಾಂಚ್. ಈಗ GMFC ಬ್ರಾಂಚ್ ಕೊಟ್ಬಿಟ್ಟು MFS ಸ್ಕೂಟ್ನಿ ಫಸ್ಟ್ ಕೊಟ್ಬಿಡಿ.
ಸರ್ ಇದು ರಿಸರ್ವ್ ಮ್ಯಾಟ್ರ್ ಚೇಂಬರ್ ಕೊಡ್ಬೇಕು.
ಅದೇನ್ ಎತ್ತಿಕ್ತಿರ್ಲಿಲ್ಲ ಅವನಲ್ವಾ? ಹೋಗ್ಲಿ ಬಿಡಿ, ಎತ್ತಿಕ್ಬಿಟ್ಟು ನೀವು.
ಸಿಗ್ನೇಚರ್ ಆಗಿಲ್ಲ ಮೇಡಮ್ ಇದು.
ಯಾವ್ದು?
ರಿಸರ್ವ್ ಅಂತ.
ಅಯ್ಯ ಕೊಟ್ ಕಳ್ಸು, ಆಮೇಲೆ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಅವ್ರು. ಇಲ್ಲ ಅಂದ್ರೆ ಅನೌನ್ಸ್ಮೆಂಟ್ ಬರ್ತದಲ್ಲ, ಹಾ ಅವಾಗ ನೋಡ್ಬಿಟ್ಟು. ಇದು RPFC.
ಇಲ್ಲಿ ಒಂದು ಫ್ಲಾಗ್ ಕೊಡಿ, ನಾನು ಹಾಕ್ಬಿಡ್ತೀನಿ ಬೇಕಾದ್ರೆ ಸಿಗ್ನೇಚರ್ ಅಂತ.
ಇದು ಒಂದು RPFC ಸ್ಕೂಟ್ನಿಗಿದೆ. MFA ಹತ್ರನೇ RPFC ಸ್ಕೂಟ್ನಿ. ಹಾ ಅಲ್ಲೇ ಅಲ್ಲ, RPFC ಅಲ್ಲೇ 3624. ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಇವಾಗ ಇದನ್ನ ಫಸ್ಟ್ ಮೇಲೆ ಇಲ್ಲಿ ಕೊಟ್ಬಿಡಿ WP GMFC, ಆಮೇಲೆ MFA ಕೊಟ್ಟೋದ್ರೆ ಅಲ್ಲಿ 2 ಕಡೆನೂ ಅದೇ ಅದೇ ನೋಡಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 15. ಥರ್ಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 15.
ಅದು ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಟುಮಾರೋ. ಏಟ್ ಕೊಡ್ರಿ
ಸಿಗ್ನೇಚರ್.